Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. I'm sure you can hear my voice is a little bit trash today. I don't know why. I hope I'm not sick or whatever, but we will soldier on through this. My jacket is sitting weird. How are you guys doing tonight? I've missed you. The past 2 nights have been so fucking frustrating. Having Spectrum just be like, oh, by the way, there's no internet for you. No internet, nothing. Don't worry about it. You don't need that. Like, no, it's kind of like how I do everything. Can you please bring it back? But today they are not doing maintenance, I guess. So, yay, I think. I think that's good. Anyway, whatever it is, we do get a show. We get to do a show. I get to see you guys, get to see me or whatever. And yeah. They're not doing maintenance yet. Every night they've started it around 11:05 to 11:10. And so I was trying to explain. They told me that maintenance was coming. They just said the maintenance was on the emergency 911 system. They didn't say the maintenance was on everything you use, which is just the internet. So anyway, hopefully we won't have that issue tonight because we have a couple things to talk about. First, we will cover my recent hearing before the Minnesota Court of Appeals. There's an oral argument in the quest to make my body cam footage public, which I am opposed to. Not my body cam, the police officer's body cam of the raid on my house that is being propagated by Joshua Moon through his lawyer, Matthew Harden, who I referred to Josh Moon. Hey, what's up, Matthew? How you doing, man? A while back. And he is basically standing in as a proxy for Josh Moon. So he is not actually the guy representing the case. The guy representing the case is a guy named Oliver Bromke, who is a North Dakota attorney who's also licensed in Minnesota. So Josh Moon and Kiwi Farms have been trying to get access to my body cam ever since I was arrested. Like that's been one of their goals kind of from the start, is to get that. There's a lot of privacy issues involved in that I'm not comfortable with. And the law, at least as far as I can read, is pretty firmly on our side on this. But it's a complicated issue. It really is. I don't want to sell it as it's completely it's completely unfounded or whatever. I think it's frivolous. I think an honest read of the law would suggest that they don't have any right to access it. Okay. But that's not what they think. And that's the realm of law and justice, right? Is to take a conflict between two positions and find the one that's either correct or sculpt a new one that no one saw coming. So we won at the district court level. Now it's at the appellate court level. And it's not the only case. There's another one too. This is all insane. But hey, it's all educational as well. Have I seen the body cam footage? Yes, I have all of it. Chris Olin, yes, I do sound sick. As far as I know, I'm not sick, but my voice is just kaput. It started yesterday, really, really amplified today. But hopefully that'll go away pretty soon. Eric PV says, Noah's throat is sore for absolutely no reason whatsoever. It's not that there's no reason. It's just that I don't know the reason. Who knows? I could have strained it, while singing or whatever. Also, it could be that I'm getting a mild cold. I don't know. We'll find out pretty soon. Okay, so we have that. We have my thing. Then we have a little story about micro penises, because apparently everybody that the media doesn't like has a micro penis now. So we all have to determine like when you're going to get your micro penis. Hitler has a micro penis, and maybe only one testicle. And Jeffrey Epstein definitely had a micro penis. And it's funny because it's like, wait, aren't there witnesses to the bodies, like to the dead people? Wasn't there an autopsy? Did they not? Maybe they didn't autopsy Epstein. They're like, no, he just killed himself. Burn him. Because that's what they did to Scalia, if you guys remember. Scalia died with his head under a pillow at a hunting lodge in Texas, completely mysteriously. Just died under a pillow. And when the cops got there, they're like, natural causes, cremate him immediately. They just take the body of one of the most prominent and famous Supreme Court justices in recent memory, and they just burned it without anybody getting to look at it. It was fucking crazy. So we have the micro penis argument or article though to go through, where everybody's got a micro penis. And we might take a pause. Well, not a pause, but we may look at a couple clips that I've been watching and talking about on Twitter that I think are kind of interesting. One is about this guy named Andrew Wilson. He was on the Whatever podcast, and he was talking to a snizzlicker, which was about the funniest thing I think you could call someone. If you don't know what a snizzlicker is, that's a dirty, disgusting lesbian who likes to lick sniz and, as he put it, clean ditches. Which I liked. I thought that was very funny. I thought that was very good. But sniz licking and ditch cleaning aside, they had like a 6-hour debate. Between this guy and this chick, and about feminism, because people are still debating this. Like, I don't really get it. There's no debate anymore on whether feminism is like good or useful or whatever. It isn't. Women don't like it. Men hate it. It doesn't get anybody anywhere. All it does is it propagates kind of this stereotypical approach to women, or of women, that let's make everything a discussion that needs to take for fucking ever. And guys are like, yeah, right, whatever, fine, fuck off. Like, we're busy. Yeah, you vote, I guess. Shit, we shouldn't have let them do that. Now they want to talk about everything. But like, it's feminism, and like they've beaten this subject to death so much. But for whatever reason, the Whatever podcast is very successful having discussions about feminism. And this guy went on there and did several of them with a bunch of different people in a row. And this particular one, he's having a discussion with this lesbian, and he's doing pretty well in the debate, I'd say. He makes his points pretty consistently. He does this all the time, so he's got it very practiced. And what ends up happening is he does the worst thing that you can do in a debate. And that is, he takes all of the work that he's done and he makes it so nobody gives a shit about any of it. And they only care about this 5 minutes. They only care about this 5 minutes because of what happens is so dramatic and kind of hilarious. So we'll probably watch that and talk about it a little bit. I think there's a really simple answer that he could have given that would have made it better. And this is not me like picking on the guy. I don't know anything about him. I know, like, just based on some things I've watched, because I was kind of looking into him, like, I've never really heard of this guy. He and I would probably disagree on a lot, and we'd probably agree on a lot, and it'd be just fine. I don't have any problem with him. His approach is a little bit, it's a little bit confrontational, but who cares? Who cares? An honest doubter says an insufferable ortho bro. Yeah, I mean, that's true. But also, like, that doesn't bother me that much. I don't really like it. It's not something that that makes me super uncomfortable. But okay, after that, depending on if we're all still alive, we got to talk about YouTube stealing, allegedly, potentially, maybe, the super chats of its creators. And of course, I'm referring to my friend Camelot 331, everybody's favorite Alabama gay NASCAR driver, who over the past several days had noticed that his revenue was in the negative, which is something that none of us thought possible. But his revenue was in the negative on YouTube. Every day he was losing $100, which is, again, really weird because I've never seen that before. But what effectively happened is someone super chatted over a long period of time, a whole bunch of money, and then went through some process. Everybody assumes it's one process or another, myself included. We don't actually know. But they went through some process to return all of those super chats. And YouTube is just taking the money from Camelot. Now, I know what some people will say is like, well, what else are they supposed to do? And that's why we should talk about it. And no matter how much we talk about it tonight, I'm going to probably cut a standalone video that is completely independent and hopefully a lot more concise about it, I think tomorrow. And hopefully I can get that put together and put up kind of early-ish in the day, because I would love it if some people could share it around. It's a type of video that a lot of people need to see, because I have some thoughts on it. We can, I don't know if we'll do it tonight or if I'll do it tomorrow, but we can look at the YouTube partner agreement and talk about how this works out. And there's two aspects to these types of things. There's what is, and then there's what's right. And that's with everything. That's with any rule, contract, law, whatever. There's what is, and then there's what ought to be. And hopefully, anytime you come across something where you go, well, it shouldn't be this, it ought to be that, it's a scenario where maybe neither party fully contemplated what might happen. And you go, okay, well, let's move closer to what ought to be if you can. And so this is not going to be like a sensational YouTube stealing my super chats video. It's not going to be a discussion like that. It's going to be a discussion. I mean, it could be. Maybe we'll do that a little bit. I don't know. Depends how I feel. But it's a discussion that really needs to happen, and creators need to be made aware of it. And we need to talk about this, because it boils down to this. You guys send in a super chat, YouTube takes 30%. So effectively, I pay a 30% fee on this transaction, or you pay a 30% fee. Who knows? But YouTube collects a 30% fee on any super chat that comes in. What the fuck is the point of the fee if YouTube can charge back? And when it comes back, if you like send in $10 and they take their 30%, and then it's refunded, they take the 10. They don't take 7. So it's really insane, because where the fuck is this 30% going? What does it mean to be a contractor? Who actually is in control of the transaction? Who should be handling the disputes? If the disputes are handled, like, who bears the burden of it? These are all the important, and I itself in real trouble if it's happening. So I think we should talk about that. Chris Olin says too many blowjobs. Oh, my voice? Yes. Is there really such a thing as too many of those? Boomer Fox says also they charge him and tell Cody, trust me, bro, as an answer. Yeah, it's crazy. It's really, really scary as a creator, which is why I want to emphasize something. There is a better way than super chats and rumble rants and everything else. And it is called Super Tip. supertip.gg/RL for Rekieta Law. Very simple. And with that, you can do stuff like this.
The internet went down. Did the internet need to drive to the Twin Cities and meet up with a service provider and exchange packages of data?
Actually, Nick's internet transmitted to the enormous girth of Kurt's gut and sprained a muscle. It could have transmitted Kurt's microphone without issue.
There you go. Yeah, and that's actually what happened to the internet. Spectrum had to perform maintenance on the internet because we kept showing images of Kurt's stomach, and the bandwidth was just eaten by Kurt, and then his stomach grew even more, and that's what happened. That's why it went down. But this is Super Tip. You know, you have two options. If you go to supertip.gg/RL, and maybe I should put that banner up as an alternative to super chats. We'll put that banner up. There's the voice tips, but not everybody wants to do that. Not everybody wants to send in a voice and have like Camelot read, illiterately read it or whatever. You don't have to. You can just send in a text message. You have the voice tip and the text tip option. And either way, it's just the tip. Okay, so it's not going to fully plow your bank account, but you can go to the text tip and you can send in a anything you want, just like a super chat. I have the moderation. There is some moderation on there. I have them. It's set to the lowest level possible, so it should be more flexible than super chats and stuff. You should be able to say more stuff. But if you want me to read it, just do those text tips, and I'll read it like a regular super chat. The other advantage of super tips is that the money comes to the creator right away. They only take 10% instead of 30%. Huge, very important. And now, as we've seen, which is kind of critical, the payment processor for Super Tip is Stripe currently. I don't know if they're going to add more later, but it's currently Stripe. And so with Stripe, if there's a dispute on a charge or a chargeback or whatever, I handle that. Well, I handle it with Stripe. We handle it together. We hold each other by our genitalia, and we handle it together. And so it gives me some control and authority over this thing. Whereas with Super Chat and YouTube, as we'll discuss, YouTube says in the partner agreement that they will send you details about any chargebacks, and they will they will send you a link to where you can appeal them and appeal the chargeback and fight against it. They didn't do that for Camelot. They didn't do that at all. So he never got any communication from YouTube. They just started taking money. But again, that's kind of the last story that we'll get to today, probably. All right, here we go. We got this.
Glad to pop in. And here we are talking about Micropeens. Because after the last 2 days of blue balling, Kurt has been demoted. Rackets is now King Micropeen. It better rhyme, that shit.
There we go. King Micropeen. Watch out, I'm smaller than everybody.
Oh, gentle viewers, gather ye near, for on this blessed eve, the streamer who vanished like Hamlet's father hath now reappeared. Praise be, he doth indeed stream, unlike the past 2 sorrow-laden days.
My apologies. Believe me, I was so fucking mad.
Hey, CR, what are going to do now that 18? BF moving out and joining OF. Be sure to free Sunny from the bathroom.
Oh my God. So let's see. That I think that is a chat to my son, who did just turn 18. So it's been also a source of just shit you're not ready for. It's like, oh yeah, your kid's an adult. Like, oh my God, but he's like a child. That doesn't make sense. And then you think back, you're like, oh, I guess so was I. I guess I was a child too. Grifty says, gifted 5 membos. YouTube took my money. Gift didn't go through. YouTube is asshole. Wait, what? That's lame. That is lame. Jen Lemons, welcome to Paralegal. How you doing, Jen? It was nice to see you the other day. Thanks for joining the channel. And by the way, of course, gifted memberships are really appreciated. We do a members-only stream at least once a week on the weekends. It tends to be Cooking with Kurt. We are coming up to the biggest of dogs. The Beef Wellington stream is coming very soon. I will say this about the Beef Wellington stream. I don't want anybody to be afraid. As much as I love to have guests on to riff and make fun of stuff, the Beef Wellington stream is just you and me, baby. Just you and me, nobody else. We are going to go through that. There's not going to be anybody else. It's just us. It's just us. So we are going to do that Beef Wellington stream together very soon. I'm not sure if it'll be this weekend. We'll figure it out. We'll figure it out. Also, I do final note. I will be finishing the porn star beheading her boyfriend, who was the father of her husband. I'll be finishing that stream. Or that trial. Like, we're going to keep going on that. That's not over. It's just been complicated the past couple days. Hugo Atano says, didn't the first person who tried to get the body cam from your house a pedo, or am I mistaken? Yeah, that was the first request. The first request that came in for document production was yes, someone who if I remember right, I believe was on Kiwi Farms, and also was a pedophile in the sex offender registry.
Your Honor, Nick is frankly a boy kisser.
Wait, I don't think that showed up. Hold on, what was that?
Your Honor, Nick is frankly a boy kisser.
Not on the mouth. Anyway, thank you, Dark Cookies, for that one. That was great. Miss Jessica says, "Oh, that corn star finished him." Yeah, I mean that was a pretty intense finish. I bet he's never had one like that before or since. Probably. So let's see. What do we got? Yeah, Maestro Dello Sperma. I'm noticing my camera lagging a lot. I'm not sure what causes that. It sometimes it's worse. I think it's a memory leak issue on StreamYard. I think, but I don't know. It's very, very annoying. But it's one of those things that I've been. It was happening a while back. There's not like a fix for it that's easy. I've tried a whole bunch of different shit. I will try more. I'm trying to fix it all the time, but sometimes it's less noticeable.
Gee, thanks YouTube. Can you at least use some lube next time?
Camelot got done dirty by YouTube, and we will be talking about it. But first, let's do this. We're going to share. So here we go. This is an audio recording only. I So this is an appellate hearing. There's nothing for me to do there. I can't offer testimony or anything. I did not see the beginning of the hearing. So that's when the attorney for Kiwi Farms, Owen Bromke, or maybe Oliver Bromke. That's when he gave his argument. I didn't see this part of it. So this will be fresh for me. I did see when my lawyer made his argument, and just in case, so this is really, this is an interesting thing. Okay. I know everything's so peachy and everything's perfect, and none of this could possibly be true. But if you look here, it's Matthew Harden is the appellant versus the state of Minnesota, who's the respondent, and Nicholas Robert Rekieta, who is also the respondent. That means there's two parties to this. And a lawyer for the state of Minnesota is the county attorney of Candiota County, my county, who just didn't show up. No big deal, right? Just decided not to appear at the hearing. Don't know why. Don't have a reason. If you were an attorney in Minnesota and you don't show up for the hearing and you don't have a damn good reason, they suspend your license or even terminate it. If your client complains. Like if it's just out of the blue, or if the judge complains, if the judge is like, hey, where's that guy? They refer you. So he just didn't show up. So luckily, though, my lawyer was able to handle the entire argument. You'll hear about it on the recording. I know you'd like to see it. There isn't a video recording of it. I have a video of my lawyer's part on, but it's all done by Zoom, so it's not like cool or anything. It's just a bunch of faces. But I just love that because it's like this whole thing's insane anyway. And Broken Baker and their viewers just joined. Hey, what's up? Welcome to the viewers from Broken Baker. Hope you're happy to be here. We're about to listen to my hearing, but there's a super tip here.
Glad to see you back. Felt like I lost a brother for a year. Love your brother from another mother.
Hey, what's up?
Please fat shame me as I just stopped drinking and need to lose 20 bags.
You need 20 what? Ronnie, what was that? It's pounds. It's pounds. Mr. Miller, you need to lose 20 pounds. That's cute. That's cute. But like men with their body count, let's go ahead and adjust it to the really thing. You need to lose 60 pounds because you're fucking fat. Disgusting grease monster. Probably tried to type 60, actually. I believe you're an honest person. I think your fingers are just too much like kielbasa's. You didn't have a chance to hit the right button on the keypad. And that is pretty pathetic. Why don't you stop shoving cheese in your face? Oh, you had to quit drinking? Oh, is that hard? Is it hard on you? Are you getting a little fat? You porky piece of shit. Oh, you had to stop? Well, I pity you so much. Why don't you stop rolling around in Cheeto dust, get off your ass, and get on a treadmill? Why don't you try that? If the treadmill is able to bear your massive belly, maybe you'll lose some of the weight. Or you'll die trying. Either way, the weight will be gone and the earth will be better because of your massive fatness disappearing. Good Lord. You come into someone's house and you're just like, oh, shame me, please. Ew, just disgusting. All right, let's do this. Let's start this up. So here we go.
All right, very good. We'll have the marshal call court back into session.
Minnesota Court of Appeals.
Oh, I clicked on Runkle's channel today just for a second. He was live. I popped in there for a minute and he's covering the cocaine lawyer. And I was like, I'm sorry. What? My nose is itching. It's burning. It's tingling. I think someone's talking about me, but it wasn't. It was about a different lawyer who had so much cocaine. Whoa. So much fucking cocaine is crazy. Grifty with 5 gifted memberships. Thank you very much. And I do want you to know, that I fat shame myself pretty much every minute of the day. And I don't take that lightly, pun intended. For the past week and a half now, I've been in the gym all except for one day. And so I take it very seriously. Fatness is an epidemic. It needs to be stopped. We all have to fight our own battles. So I'm not sitting here just telling other people to do it. I'm getting my ass out of bed and doing it too.
Appeals is now in session. Chief Judge Frisch, Judge Cochran, Judge Kirk, the Honorable Jennifer Frisch presiding.
Good morning, Council. Today is November 18, 2025. Welcome to the Minnesota Court of Appeals. This is the second of 6 cases that we are considering on today's calendar, A251039, Hardin versus Rekieta and the state of Minnesota. Council, if I pronounce those names.
Rekieta. The K is before the T and there's vowels. Always, every fucking time. Life in General says, yeah, standing in the corner with a Snickers drooling over the guys lifting weights. How do you know me?
Names incorrectly, please correct me once your time begins. You're familiar with our proceedings. You'll each have 15 minutes for your primary argument. The appellant has an additional 5 minutes for rebuttal. We ask that you identify yourself and your client before you begin speaking. Also, let us know how we can reference you this morning. These matters are being recorded. That is the only recording that is permitted. And with that, Council, we are ready for you whenever you are ready.
Thank you, Your Honor. May it please the court, my name is Oliver Bromke. I represent appellant Matthew Hardin in this matter. Other parties are the state of North Dakota and Nicholas Robert Rekieta, represented by Mr. White. This appeal centers on the public's constitutional and common law right of access to judicial records in a criminal proceeding, specifically whether uploads to the Minnesota Digital Exhibit System, or MINDES, cited in a party's memorandum but not formally admitted as evidence qualify as public judicial records. The district court initially granted my client, Mr. Hardin's, access to those records, acknowledging their judicial nature, but later reversed course after an ex parte motion.
Okay. So this is the appeals court. Each side gets 15 minutes of time. That's it. That's all you get. 15 minutes. There's no witnesses or anything like that. You get a 15-minute argument. And in this case, the appellant is going first. And so he has taken 10 minutes and reserved 5 minutes of his time, or he will at the end of his argument. One of those two. He's going to reserve 5 minutes to go ahead and do a rebuttal afterwards. But that's all you get. And it is a hard limit. I mean, once you hit 10 minutes, unless you're answering a judge's question and you're answering it very quickly, they're going to cut you off and shut you up right away. Their position, and this is going to become more of an issue as we go. So it's always tough to decide how much to go back and explain on all this. This is governed by 2 basic things. One is in the executive branch, and that's by a statute called the Government Data Practices Act. And then the other is the judicial branch, and that is the publicity and public availability of evidence. Evidence that is presented in a court of law is publicly accessible by default, unless a judge is to seal that particular evidence or seal off the whole case, et cetera, et cetera. And they do that for various numbers of reasons. The question in this case is pretty much strictly related to the judicial side of it. Okay. This is because Minnesota has, during COVID, created an online filing system called Mindes. Mindes is where you file potential evidence. You put it into the system. And then at your hearing, you offer the evidence, and then it's accepted by the court or it's not. And when it is offered and accepted, it becomes evidence and part of the evidentiary record. That's what makes it public. If it does not become part of the evidentiary record, it does not become public. And then it would be governed by other laws. And in this case, the Data Practices Act, which governs body cam footage. Body cam footage is confidential during an investigation, an active investigation, and body cam footage is private after that investigation. Private means to obtain the body cam footage, you would need the consent of every non-government person who appears in that body cam footage. Sometimes they will allow certain people to be redacted out if they cannot obtain consent, but it really depends on the circumstances, how much redacting needs to be done, all of that stuff. But generally, it is considered private data that belongs to the subjects of the data, and it can't be released generally to the public. In fact, if it is unlawfully released, there are significant civil remedies available to those whose privacy has been breached. And those claims are taken against the state of Minnesota. So that's the Government Data Practices Act. And specifically under the Government Data Practices Act, hope you're listening, there is no state immunity or qualified immunity. They do not get to have immunity under the Data Practices Act. If something is private and it is leaked, like say when you're arrested and someone leaks the confidential and private police report, maybe by taking a photo of it from the sheriff's office at the county and posting it on Twitter. If that happens, for example, each plaintiff has a civil remedy of any economic damages, any specific damages, and also a statutory remedy of $1,000 to $15,000 per plaintiff, unless the court determines that it's willful, in which case that's doubled to $2,000 to $30,000 per plaintiff. So if, for example, you were to release a document that, say, impacted the privacy of 7 people, hypothetically, that is up to $30,000 a person in special damages, in addition to any economic damages, reputational harm, all of that stuff, and it can get very, very expensive for the government if someone happened to do that. I don't know why. I don't know why I would bring that up. So, that's the Government Data Practices Act. This portion is again under the judiciary. Their claim is that this became part of the evidentiary record. Now that's really muddied up because the Mindes system, like I said, you upload to the Mindes system, and then after a hearing, evidence is either classified as evidence or not. And in this case, the court clerk or court administrator, whoever, someone from, I don't mean the court administrator as an individual. I mean someone from the administrator's office, mislabeled the body cams as evidence. Two of the body cams that were in the system were mislabeled as evidence. So the claim by Oliver Bromke is that as they were mislabeled by evidence, now they are public, which has some legal problems with it that will become apparent very quickly. I apologize for going through all this backstory in like a really convoluted way. again, it's hard to, this is a really complex legal issue, and it's a novel legal issue. Like this doesn't happen. These claims don't happen because the courts aren't ready for social media. I've been saying that for years and years and years. They are so far behind on technology. They're not ready for what social media is.
You will now be known by law as Nick Retka. Suck it.
Funny story. It's not funny at all. I went to, high school with someone whose last name was Retka. And I was like, well, that's wrong. It's just incorrect.
By the state to correct the record, denying access without allowing Mr. Hardin a chance to be heard. We're asking this question.
Mongoose Dog says, how long are you going to milk this? I have no control over when this ends at all. I don't have any control over this. This is a case brought by Joshua Moon. He could stop pursuing it at any time. Until he stops pursuing it, I will fight it.
Court to reverse that denial and remand with instructions to grant access, or alternatively to afford Mr. Hardin a hearing to rebut the adverse factual findings made against him as an intervener.
Counsel, before you get in.
So this is the other part of appellate arguments that you may not be used to if you don't look. This is different than district court. Remember, this is you as the lawyer talking to a panel of 3 judges. You stand before them and you have your 15-minute speech prepared and you start saying it, and then they interrupt you and ask questions and your speech is derailed entirely. So that will happen.
To the merits of the right to the information itself. I have some questions about the procedure that was used here. I don't see anything in the rules this is a criminal proceeding. That's the underlying proceeding. I don't see any mechanism in the criminal rules that allows a private third party to intervene and for this purpose or any other purpose.
Okay, so this is another procedural aspect of the case that is weird and without legal foundation. Joshua Moon's attorney, Matthew Hardin, made a motion to intervene in the criminal case. Now, there is no rule allowing intervention in a criminal case. You could see the problem with intervention in a criminal case. Intervention is where a party makes the claim that they have a legal right or a legal, necessity to be a part of the case, so that they will better represent what is going on than a named party. So that's intervening. Impleading is bringing someone into the case as an addition. Intervening is to stand in front of some other party. So Matthew Hardin attempted to intervene in the criminal case. The problem with this is, imagine if you could intervene in a criminal case on either side. Well, nope, I'm more responsible than the defendant. That doesn't make, I don't know why someone would want to do that, although they could show that, they're more responsible, but they're not guilty, and then let the defendant who may be guilty go free, I guess. The other thing is, imagine if you could intervene on behalf of the state. If you could intervene on behalf of the state, then you basically allow private prosecutions, and that's something we don't typically do. A couple states have some ways to do something like that, but they're the ones that are around are archaic and draconian and going away, because we don't let individuals use the criminal apparatus of government to go after other individuals. That's fucking insane.
Can you point me to some authority that allows for that procedure in a criminal proceeding?
Sure, Your Honor. Intervention is the canonical vehicle for third-party access enforcement. I believe the case I cited was Providence Journal. Especially when there's a First Amendment issue lurking here, criminal cases demand public scrutiny to keep the system accountable, especially in situations like this one where it appears.
So this is a conflation that we'll see a lot of going through, and I'm sorry, I'm going to offer significant commentary on this because it's really frustrating having to have other people do this for you. It's frustrating, but that being said. They are claiming that the public has a right of access to the case, and that's going to be kind of the largest part of their argument, and that's true. The public has a right of access to review court records in criminal cases. The problem that they're skipping and they're really trying to avoid is that this isn't part of the record. So the reason that there's a right of public access to review criminal trials is to make sure the government isn't fucking somebody over by prosecuting them under secrecy, like using the FISA court, for example. When the FISA court is used against you, you don't even have access to the FISA court documents or the decisions that the FISA court is relying on to make its rulings. It's really difficult to fight, and you have to hire a specialist attorney with certain security clearance, and he can't talk to you about anything. He can only draft the confidential motions, which would be classified. It's kind of wild. But the public does have a right of access. I know the FISA court exists, but they have a right of access to make sure that there's not some government abuse going on in the prosecutions. Now, that requires something to be part of the evidentiary record, though, because it has to be used against the person to be reviewed. And they're going to try and make the claim that this is some sort of hidden document that was used to prosecute, which it isn't at all. A hidden document that's used to prosecute. That claim is actually stupid because the people who were potentially going to use this was going to be us. So that wouldn't be used in the prosecution. It would be used in the defense, in which case the right of public access maybe doesn't apply. That's a bigger issue that doesn't get addressed in any of this, as far as I know. It would be kind of the next step argument if that were the case.
That the prosecution.
Eric Duff says body cam footage is available through FOIA requests. No, not in Minnesota. It is in Florida. People think that you can get any body cam footage that's out there because so much of it is from Florida. Florida is called the Sunshine State for multiple reasons. One of them is that they have a very open records policy. Minnesota does not have that same policy. Minnesota body cam footage is only publicly accessible if an officer discharges their weapon in the body cam footage, or a civilian dies in the body cam footage. Then, like, those are open to public scrutiny, right? Which makes some sense. But otherwise, in Minnesota, body cam footage is private, which means the right of privacy is held by the subjects of the video individually, every single one of them, which means any non-government person captured on a body cam video must give consent to have the video released.
In the defense in the underlying criminal case were of the same mind and filed a motion that both of them constructively adopted.
But the mechanism in that case was not intervention in a criminal case, was it? I'm just not aware of any authority that allows a private third party to intervene in a criminal case to seek the kind of relief that you're seeking. I mean, I'm putting aside the question of whether you have a right under some other procedure. I just am questioning whether this procedure is authorized by law or our rules.
Well, the right to intervene here, it flows from the constitutional right of public access itself. Under the cases I cited, Sargent and Ledoux, procedural rules.
Ms. Jessica MB1 says, so all documents essentially sealed until it's admitted for the court. They're not sealed. Sealing is a little bit different. Once it's sealed, nobody can release them during the pendency of the court action, or the pendency of the order, I should say, the sealing order, which is actually possibly an interesting question here. And as you remind me of it, I'll have to mention it to my lawyer, I'm guessing, because it might need to be, I believe there's maybe some supplemental briefing that is going to happen, and this is probably relevant and maybe overlooked. The body cam footage itself is actually part of a sealed case. So that's a different problem altogether. But a sealing, an order sealing certain things means they cannot be released by parties to that case, or actually by anybody. So who's under the court's jurisdiction. So you've got an issue there in that. But documents, if a case is not sealed though, and something's not evidence, it can be released. It's just permissive. The people who own the right to the document own the right to release it. In any other way that it could come out is applicable. But they're not pursuing some other method, right? Like, no one's called me up and offered me X amount of money. I would still say no, but no one's called me up and offered me X amount of money, for example, to release the document. In theory, like, someone could do that, or I could choose to release it. Well, it's not, the videos, but that's not happening here. They're asking the government to release it, but the government doesn't hold the right to release it. And that's a critical element of this. Now, if it becomes part of the evidentiary record, if it's admitted to and accepted by the court, offered to and accepted by the court and admitted into evidence. Sorry, I said that wrong. If it's offered to the court, accepted by the court, and then admitted into evidence, then it becomes part of the evidentiary record. That is public unless it's otherwise sealed. Sorry, it's kind of confusing, but trying to answer these questions the best I can. What's up, Jim Tells You, and welcome to the viewers of Jim, my friend Jim, and I hope you enjoyed his show. Welcome here.
But Mr. Bromke, I think the question is there any rule of criminal procedure that allows for intervention in a criminal proceeding to access court records?
I believe that the district court, in the order that allowed for the intervention for the limited purpose, specifically pointed to the common law right of access with respect to its basis for allowing Mr. Hardin to intervene for purpose of making the request that he did.
And I think the court noted that there wasn't any specific rule of criminal procedure that would allow for intervention, correct?
I believe that is the case, yes.
And so isn't there another procedural mechanism that is available and provided for, which would be a petition for a writ of prohibition or a mandamus to seek access to judicial records, as has been used in some of the cases that you cited?
Had the court outright denied our request, we would have sought relief.
Welcome to Good Logic. Another raid has hit the stream, at least on Rumble. I didn't see if he hit us on YouTube, but I assume he did. Welcome to Good Logic's viewers. You're in good company here, and we have some appellate court hearings about me going on right now. So what he just said was that the district court denied their request. The district court didn't initially deny the request when it was mistakenly labeled as evidence. The district court did allow two people on behalf of Matthew Hardin to see the body cam footage in person. That was not lawful. I don't know what else to say about that. That was not a lawful act, but you do what you do.
In that manner, but in the interest of judicial efficiency, we sought access this way instead.
And you can still seek access through regular civil proceedings, yes?
Yes, but with respect to challenging adverse factual findings in the writ of mandamus context, I'm not exactly certain how the court expects us to do that necessarily. It's just a.
So this is an interesting question and answer exchange. The judge, the appellate judge, remember, this is limited to, is this a question, or this is a question for the judicial access to the court records. If they're not court records, you have to use some other process. And the judge who's asking him a question says, hey, why aren't you, can't you just go through the other processes for this? He has to tread kind of carefully, because his answer is yes, but the law is pretty fucking express that they don't have any right to this footage. And so he's saying, yes, but like, I don't know how the court would expect us to do this, which means we know we'll get butt fucked if we try. They have a problem. The problem is they don't have any legal authority to support their position. Dragon Red says, Nick, you still have not commented on these judges. You know, these are the personalities that would otherwise drive you nuts, but you're letting it slide. Well, two reasons. One, I've, a vested interest in not commenting on the personalities of the judges. Two, I didn't really there's not much to the personalities of the judges. There's the chief judge of the appellate court is sitting in this one. I don't remember her name. The judge who's talking now is not the chief judge, but she does most of the questioning throughout. And then there's those two are females. There's a male judge. He doesn't ask too many questions throughout the hearing. But as far as their personalities, I don't know any of these people. I don't watch any of their other things. I'm not sure what their judicial perspectives are. Right now, they're asking questions based on the briefs that were submitted. And the questions they're asking this guy, which is Oliver Bromke, all revolve around, one, why are you trying to do this through this process? Two, they're going to get to the questions of, do you have any legal foundation anywhere for any of this? And his answer is good.
Constitutional principle that we're asserting here.
I understand, counsel, but it does seem incongruous for a third party to be seeking a civil remedy, which, the collateral consequences of which delay a criminal proceeding. And I have constitutional concerns about that also.
Well,
and is there any jurisdiction anywhere in the country that allows for this kind of procedure?
As a matter, in terms of, you previously asked about whether Minnesota specifically allows for it. Minnesota rules of criminal procedure don't explicitly incorporate a remedy of this type, but many jurisdictions, including the federal courts, routinely recognize it. And we cited that in the district court brief.
Routinely recognize what? A right of intervention in a criminal case?
Well, for the purpose of seeking public access to court documents.
So the judges here, notice the judge's kind of incredulous tone there, because he says very casually, oh, this is commonly done. It's not. Let's get that out there right away. This is not commonly done. And it's much less commonly done in Minnesota. Where it is the most commonly done involves cases against the FBI. It typically, we're talking most of the cases. In fact, I think all of the cases that they cite in this, none of them are from the 8th Judicial District, or the 8th Circuit. None of them are from the 8th Circuit, which is where Minnesota is. We're talking 2nd Circuit and, federal courts in general, because they're typically against the federal government, who has national security interests that make some things secret. Those things, that's where the right of public access comes in. Hey, you can't prosecute people under secret laws and secret rules. State governments don't do that so much. State governments may have corruption, right? State governments may prosecute people with corruption. We saw in the Karen Reed case, there's likely a lot of corruption going there. It sure didn't pass the sniff test, so we can infer that. But it's not because there's a secret rule or secret documents that the state of Massachusetts was using against Karen Reed. It's that you had a corrupt judge that was connected to a bunch of crooked cops, right? That's what's going on over there. In the federal government, there are literally secret laws. There are laws and rules that pertain to national security, procedures that have to go through people that cannot be named. Their identities must be kept secret, CIA agents, foreign intelligence officials, and stuff like that. And so frequently, the federal government is involved in using documents that are not publicly available. And that is where this proceeding that he's talking about, this right of intervention into a criminal procedure, comes into place more frequently. that's when you go, hey, you don't get to do this. The public gets to see why you're going after this. And he's going to cite cases. Almost all of these cases involve the prosecution of terrorists, because that's who runs into this issue the most. Hey, we have national security issues. We're prosecuting foreign actors or foreign combatants. And that, that has its own set of complications. They're trying to conflate that with body cam footage in Minnesota that wasn't used in the criminal case at all. And that is going to be the problem. So he's casually saying, oh, this happens all the time. And she's like, oh, really? Does it? There's not a rule for intervention in a criminal case in Minnesota. It doesn't exist. In fact, there's not a federal rule for it, I don't believe. If there is, it's the federal rules of criminal procedure. I haven't read through them. I didn't practice since law school. I didn't practice in federal court. So, I don't know off the top of my head if there is a rule about that. If there is, it's one of the obscure ones. This is not a procedure that's done with any relative frequency.
What's the best case that stands for that proposition?
Apologies, looking through.
He's looking for it.
Or is there a rule of federal criminal procedure that allows for intervention for purposes of by a third party for purposes of obtaining a civil remedy?
This long period of silence where she said, do you have a case? And then after 20 to 30 seconds of uncomfortable silence, is there a rule? And he's still quiet. This is not where you want to be in front of the appeals court. You do not you should, if there's a case on this, he would have it, presumably.
I mean, Mr. Bromke, you can see what our concern is. I mean, this isn't the only criminal case where there's evidence that is produced, and I have concerns about allowing for civil intervention that would necessarily delay criminal proceedings, as a matter of procedural course, which is probably why we don't have a rule of criminal procedure allowing for it. So why would we allow this kind of procedure to occur as opposed to directing your client to engage in regular civil remedies?
Because the result is going to be the same regardless. We're going to be arguing about the same issue, and this is simply the most convenient forum in which to litigate it given what's already been filed.
I mean, the result might be the same for you, but the result is not the same for a criminal defendant. Wouldn't you agree?
Well, that's true, but in this case, the underlying criminal case is already more or less concluded. We've gotten past the disposition phase. The state is arguing we're stopped by this criminal order from making arguments in the civil case. So in terms of who this materially affects, I would say that it's us.
Can you point me, let's just turn to the merits for a moment. Can you point me to where in the rules of public access to judicial records that indicates that a document that was never received as an exhibit, was never, there was an administrative error in entering the document in Mindy's, that administrative error would render the document an exhibit for purposes of determining whether it is a public record?
Well, the public access laws talk about what's presented, not what's offered and accepted pursuant.
Okay, before he gets into this argument, which is interesting, although it's terrible, the judge here is very clear. Everyone acknowledges that the labeling of this body cam footage as evidence was a mistake. It was an error. The court remedied that error. The judge issued an order, says, okay, no, this is not evidence. It was not offered. It was not accepted. This is not part of the evidentiary record. Very clear on that. So judge is like, so this judge, the appellate judge, is like, okay, so we're all clear that this is a mistake. And the court then remedied the mistake. Why does that error suddenly grant you access to this thing? And mind you, what Bromke is doing here is a very crafty technique. Bromke is using concepts of public access to make sure the prosecution was legitimate or whatever, right? That's what he's saying. That's a lie. That's a bald-faced lie from Bromke. He is lying to the appellate court. He's lied to the district court. That is not the purpose of this. Josh Moon, who has hired Matthew Hardin to do this as his stand, as his proxy, has openly stated that that is not the intention of obtaining the body cam footage. The intention of obtaining the body cam footage by Joshua Moon is to air it publicly for the purposes of what he perceives will be humiliating me. So to go before the appeals court and to say that what you're doing is trying to make sure a prosecution was valid, especially in a case where there is a guilty plea to the facts that were effectively laid out, at least insofar as the drugs are concerned, there is no need to validate the prosecution because a plea agreement was reached and I admitted to the facts that were alleged against me, to wit, that I was in possession of a mixture of approximately 19 grams of cocaine, a mixture of cocaine, Molly, and ketamine. Now, it wasn't mixed, it was in separate bags, but for the purposes of prosecution under that possession law, they consider it all a mixture of the same thing. So under that, the facts are not in dispute between the two parties. So the question that this was somehow that they're somehow acting on behalf of the public and making sure that there was some sort of meritorious prosecution. Well, we know there was a meritorious prosecution because I in the state agree that the prosecution was meritorious insofar as the facts as presented. I did not complain or challenge the body cam footage itself or anything in regards to the factual record. What I challenged was the validity of the warrant. Those are different things, right? The execution of the warrant is because the validity of the warrant is in question, but how they executed the warrant and what they found was not challenged. We didn't get to any place where we could challenge that, and I then admitted to those facts and pled guilty. So he is doing this legal ninjutsu. If this were like a Discovery documentary, it'd be something like that. They'd say, "Now use legal ninjutsu to flip the script here." The person who wants the documents to remain private is the privacy rights holder, which is me, right? The government doesn't have like any specific position on it other than what their legal obligations are. I don't think they care one way or another. Like if I tried to release them, I don't think the government would be opposed. But they don't have any right to release them on their own. So he's trying to use procedures and arguments that are geared towards wresting control of documents from the government to wrest control of documents from private citizen. And it's very dishonest that he's doing it, especially when his client's client, who his client is standing in proxy for, has openly stated the opposite intention on multiple occasions. Not like that's ever going to come up again.
Into the evidentiary rules, presentation is a broad term. You've got Minnesota's rule on sanctions, for example, saying you can't file or present to a court a motion without 21 days notice. It's got to be considered a distinct concept from offering, or else it's surplusage. Here, the body cam footage at issue was presented by a criminal defendant, Nicholas Rekieta, in support of his motion to suppress, in which he accused.
Well, it wasn't presented, though. It was cited in the motion. And my understanding is typically in a criminal proceeding, a legal brief framing the argument that will be, the legal argument is filed, but the actual exhibits are not filed. They are offered at the hearing. Now you can talk about that in your response, but I don't think it was presented. I think the record reflects that it was cited in the legal brief and uploaded into Mindy's. And as you know, Mindy's is a newer system, and there is a Supreme Court order governing.
The chairman Lamau says, aren't there lots of times when innocent people plead guilty because of prosecutorial deals versus possible full conviction, even though they're innocent? Yeah, there are. Do we think that's the case here? Do you think I was coerced after hours of interrogation into pleading guilty because to facts that weren't true? I mean, I've stated openly multiple times that the drugs in the house were mine. You know, they were in a safe that was owned by me. I was the only person with the combination to the safe. You know, like I've admitted to all of this. Those facts aren't in dispute. So yeah, I mean, there is theoretically like something where you go, okay, well, there was abuse here, and then that abuse led to a coerced plea. Sure, like you can make that case. That's not the case they're making, though. Here we go. What's this?
Good to know there's a Bronca collaboration in the future. It's only right I should be there too.
You will be. You will be. Yes. Brunga and I, I just got a text from him the other day. We'll be talking about planning for the Courtney Clenny trial, which is Q1 of next year. All right. So I would like to talk to him before that because I love that guy. He's fucking hilarious. He's crushing his schedule right now. And my schedule is like non-existent. It's in constant flux and chaos, which is really frustrating, but that's just where it is. Once things kind of like get locked in for me, you know, I'd be happy to have Bronca on, go on his show, etc. Mongoose Dog says you wouldn't be acting this worried if they were losing. Mongoose Dog, I don't know how to better explain this to you. They lost. They lost at the district court. That's why they have appealed to the Minnesota Court of Appeals. And they really have a problem with their arguments in that they don't have legal support for it. That's not me being worried. That's the facts of the matter. And it will be basically discussed by the judge and the lawyer here in just a minute that he has no legal authority. He's going to cite to a case called FAREH, F-A-R-E-H. I think it's U.S. v. FAREH, F-A-R-E-H. And that will be his support for why you can intervene in a criminal case for access to secret documents. But we're talking about, again, publishing some or going after someone for, if I'm not mistaken, being members of ISIL or ISIS, and the government having policies that they were enforcing that were not public. This is a completely different question, and that's the best case they have on point for it. And again, that comes out in the hearing if you'll listen. Look, I've said from the start, I believe that they don't have the legal foundation for it. I'm open to hear the legal foundation for it. I think they're going to lose, but you know, this is a new issue. There's no Minnesota support for it. There's no 8th Circuit rulings on this, and there's no Minnesota state level rulings on this. There's nothing. This is a relatively new process. And part of the reason for that, though, is because Mindes is a new system. It was implemented in 2020. And so an error with Mindes, you know, the appellate court, I guess, could try and decide that, you know, an erroneously labeled item in Mindes is sufficient to allow the release. The appellate court is going to explain here, and I know you haven't listened to this, but I have. The appellate court's going to explain here, though, that the Supreme Court has made a specific ruling that items uploaded to Mindes, but not offered and accepted into the case, are not part of the evidentiary record. So, and the court's going to ask him, how are we supposed to go against the Supreme Court? That's not the role of the appellate court. The appellate court's role is not to go against the Supreme Court, it's to uphold what the Supreme Court precedent states. So you've got a problem here. The problem is they don't have persuasive authority on their side, except one case from the Second Circuit, which involves a completely different question involving federal prosecution of foreign agents. That's the only the closest they can come. They have nothing from Minnesota. And on top of that, you have a specific Minnesota Supreme Court case that says the opposite of what they want. It's crippling. Does that mean I'm going to win? No. This is court. As I've said for the entire duration of this channel, you can be very confident on the law and the facts and still lose because it involves people. It involves people making decisions. It involves people being persuasive. It involves people being persuaded. There's a human element to law. And as long as there's a human element to law, you always are going to have a degree of uncertainty. Am I pretty confident that we'll win? Fairly confident, yes. The law is pretty clear at this point. Does that mean we will? No. But we'll see. So far, we won at the district court level. We'll see what happens at the appellate court level within 90 days.
That which says specifically that exhibits in Mindy's offered in court proceedings are case records. Exhibits uploaded and stored in Mindy's but not offered to the court are not case records of the Minnesota Judicial Branch as defined in the rules of public access and are not publicly accessible.
There it is, right there. It's not publicly accessible.
So
Right. Oh, sorry.
I think the question is not whether it was, you're using the word presented. I think the real question is whether these video exhibits were ever offered.
And I would take a different position. Offered and received are evidentiary terms of art. They govern what becomes part of the evidentiary record for purposes of proof at a hearing or trial. But the right of public access doesn't turn on evidentiary admissibility. It turns on whether a document is presented to the court for purpose of influencing a judicial decision.
Now, okay, so he's the rule is about offering and accepting. He's saying that there's a rule that says presented to the court. Importantly, this wasn't presented to the court. This wasn't at any time actually presented to the court in the case that they're talking about, which is the Minnesota criminal case against me. We had put it into Mindes, which again is just a digital evidence onboarding system. That's all it is. It's the place where you put your evidence so that when you're in court, you can offer to the court this digital evidence. They implemented it during COVID because people weren't there in person to hand a document to the person sitting on the witness stand, right? Okay. So we uploaded it to Mindes. When we went to the omnibus hearing, which is where this issue might have come up, the issue in question was the Sixth Amendment rights being violated for April. We had made an argument in our motion about that. However, that portion of the motion was mooted as the court asked both my lawyer and the counsel for the county, and both of them said this issue, we've actually come to an agreement on this issue. It's not necessary for the court to address it. He's trying to say that because the body cam footage is cited or referenced in the motion, that the body cam footage itself was presented to the court. And he's making a distinction of presenting versus offering and accepting. What he's glossing here, and this is how you do law. Okay. He's not doing anything wrong with this. It's not like unethical, but he is glossing something here, is that presentation is also an evidentiary term of art. He's glossing past that. Presentation of evidence to the court is for the purposes of the court determining admissibility. We didn't even get to that stage. This was never presented to the court for the purposes of determining admissibility, nor was it offered to be admitted, nor was it accepted and admitted. So none of the things that need to happen. He is trying to gloss that presentation term and ignore that it is also a term of art in evidence. And that's a really important failure of his argument, because if the appellate judges go back through the transcript or through this, I'm sure they already caught it, but if they go back through, they're going to say, yeah, he kind of like skimmed over the part where it's not presented anywhere to the court. That never actually happened. So even if the rule were expanded to allow it to include presentation, where the court has reviewed it to determine its admissibility, he's still got a problem.
And what case are you citing to? Because I think the case law talks about documents being filed, not presented. So what case or rule are you relying on when you're using the word presented?
And the important part is his answer right here. So you're saying that it's presented. What case or rule is it?
The specific issue at hand here is so new, given the newness of Mindy's, that I don't believe that there is a specific Minnesota Supreme Court case or appellate court case on point to that issue. But
okay, so there isn't a case. So he made up that argument out of whole cloth. Like that was all something that he made up. I don't know how to I don't know how to state it further. This is a huge problem for their case, and it shows up over and over and over again. Let's see. All right, back to this.
Distinction is built into.
Aren't we guided by the Supreme Court's order? I mean, why wouldn't we follow the Supreme Court's order that says that unless a document in Mindy's is offered, it's not publicly accessible? We are an error correcting court. We are bound by Supreme Court orders.
That's what I was mentioning earlier. The appellate court is explaining to him, he knows this. I'm not trying to suggest that he doesn't, that they don't have the authority to change, the Supreme Court ruling. Like that's not what they are for. They are to correct the errors of the district court in applying Supreme Court precedent. The Supreme Court has a ruling on this. He's saying that ruling is wrong. That's fine. But if you're saying that the Supreme Court ruling is wrong, you either have to say that it goes under a different rule, or you're going to challenge it at the Supreme Court level. And that would only be if the Supreme Court decides to take up the issue.
Because the distinction is important for preserving the right of public access by interested individuals and holding the judiciary, holding the parties to a criminal action accountable for what they filed. The distinction matters because presenting is the functional act of placing a document before the court to adjudicate rights.
But you have no legal authority to support your position on presenting.
The Minnesota Government Data Practices Act specifically says
you don't have any authority. Notice he didn't say I do. He starts talking about the Government Data Practices Act, which does not cover evidence. We'll hear that in a second.
Says presented, items that are presented are public. It doesn't say anything about offered versus accepted.
I mean, the Data Practices Act doesn't apply to judicial records.
Granted, but I'm referencing that for the purpose of establishing that there is a distinction between.
So what he's doing, his reference authority for saying that presented is distinguishable from offered and accepted, which offered and accepted comes from the Supreme Court ruling. Presented comes from the Government Data Practices Act, which is completely different than what he's doing now. He can, and they are, also trying to go at this through the Government Data Practices Act. The problem with that is they know that they have an even worse argument under that act.
Them here. I mean, regardless of what the Supreme Court has specifically said about
and in the Supreme Court's rules of public access, does it draw the same distinction?
It does not, to my understanding.
Counsel, why can't you just handle this as a data practices case?
It's being handled as a data practices case, but unfortunately, we are currently waiting for that to resolve. Whether or not that case proceeds and how it proceeds is going to probably depend on the procedural posture of this case pending this.
Lounge King 77 says, you being guilty doesn't mean the plea isn't coerced. Who's suggesting the plea was coerced? I've never suggested that. No one I know has suggested that. No one who knows me has suggested that. Josh Moon's lawyer hasn't even suggested that the plea was coerced. That's not an argument that's before the court in any way. You're right. So I mentioned that earlier. Just because someone pleads guilty doesn't mean that it wasn't coerced or somehow improper. No one's actually alleged that here. Like I said, instead of alleging that, what they're trying to do is just ride this parallel idea and hope that the appeals court doesn't notice. Guess what? The appeals court is like pretty observant of the arguments brought before it. Now, it doesn't mean that they will definitely notice, but they're pretty good at issue spotting. That's why they're judges. So we'll see.
Hey, big dog, I used to do nipple nummies. You know, when you rub some blow on some titties and suck and rub them on your gums. Oh, so good. Cheers, brother.
Hold on. I wasn't listening to that. I was doing just a second.
Hey, big dog, I used to do nipple nummies. You know, when you rub some blow on some titties and suck and rub them on your gums. Oh, so good. Cheers, brother.
Enjoy. I guess that sounds kind of fun. That sounds kind of fun. I don't think I ever tried that. I'm not saying I'm opposed. You know, I'm thinking about it. Could be a blast. No, I'm joking. Those days are over for me. So, you know, I got everything out of my system, I guess. NY Renal MD says it seems to be private until the investigation is complete. There are specific terms around this. It's actually confidential until the investigation is complete, which means even the subjects of the document cannot have access to it. So during the investigation, I can't even request the body cam footage. It is given over in discovery, which is separate because I'm being prosecuted. Let's pick someone who's not being prosecuted. For example, how do we do this? I have to do this without being personal. Oh, well, this is actually, no, because at the time she was being prosecuted. Let's say they chose not to prosecute April, for example, right? Because initially they dropped the charges against her. It was a clerical error. They meant to charge her, but they didn't. But let's say hypothetically that they didn't want to charge her for whatever reason. So they didn't charge her. So she wasn't being prosecuted in the hypothetical situation. If she wanted to have access to the body cam during the investigation, she would not be able to get it because it would be confidential. And the only tool available would be discovery. And if she's not being charged, she's not entitled to that discovery. So that's confidential. 90 days after the investigation is complete, body cam footage moves from confidential status to private status. I'm only being pedantic about this because the law is pedantic about it. You said it was private until the investigation was complete. That's not accurate under the law. It's confidential, which is a higher level of privacy, in which, well, it's not private at that point. That's where the government holds all the rights to it. After the investigation and 90 days, it becomes private, in which the individuals who are the subjects of the body cam footage have the rights. And that's every single non-government individual in the body cam footage, including if it was on the street or whatever, it would be passersby and stuff like that. They would have an individual privacy right that would say that footage cannot be released without their consent. Now, again, Minnesota allows for limited redactions. If there's like an incidental viewing, again, you're talking about someone on the street, for example, passing by, where they would, maybe redact their face if they're not involved. If it's not really possible to completely redact out someone, then they can't release it without their consent. but that's private. Okay, so there is a distinction there, and it's an important one. Like I said, not trying to be pedantic, but the law is.
Hearing. So,
But I mean, what at this point, if the investigation is over, what basis would law enforcement have to claim that it's not a public record under the Data Practices Act?
wonderful question. If you could ask the same question to the district court judge in that case, we would love it. But the findings there are adverse findings in this criminal order that we're appealing. In terms of the specific data that we're requesting, there's some, I guess, not quite, there are some minor children that are involved in the footage that would create some pause for law enforcement from releasing it. And we made Government Data Practices Act requests and they were denied. And that's currently the subject of civil litigation.
They were denied because the Government Data Practices Act is explicitly clear on the release of this type of information, the whole section on body cam footage, and it suggests that they should not have access to it.
So, counsel, in your view, when did these video exhibits that were never formally offered, when did they become judicial records in your view?
At the point at which the district court reviewed them for the purposes of finding, well, at the point at which the court reviewed them after they were filed by Mr. White in advance of the omnibus hearing, when the court took a look at what was filed and said some of this is properly brought at the motion in limine stage.
So this is a lie by the misrepresentation, lawyering, whatever you want to call it, by the opposing side. He's saying that the judge reviewed this and used his review of it to make a determination because the judge used words that my attorney wrote in his motion to say, they're or in a prior motion, which was a request to deny, like a opposition to media access or something like that, in which, it was mentioned that there are children present in the video, unredacted faces of children, and that, it would be improper to release it. So the judge relied on those statements and made this determination. He's trying to say that the judge reviewed the video. Now, this is another thing of lawyering that's going to come up, although it hasn't come up yet. Oliver Bromke is again going to misrepresent to this court what happened at the district court level, because he is going to say that the judge, he's going to try and conflate and confuse the appeals court into thinking the judge reviewed this video by citing the judge's words in a different proceeding in which the judge did review the video at the request of Matthew Hardin. So Oliver Bromke is going to suggest that because his client requested a video and a judge reviewed it in that case, which is after my sentencing hearing, that created it as an evidentiary record that could be released, even though the review was to determine that the finding the videos was in error, or in the administrative case they did. There's multiple cases on this, and he's going to try and conflate that for the appeals court, which is not a good move, because if the appeals court catches on to what he's doing, they're going to be really pissed off about it. Now, that won't happen at this hearing. That would be something that happens on review. But when they realize that he's actually talking about a separate thing and trying to represent it as this thing, they're going to be annoyed by that. Will it influence their decision? I don't know. Again, I think the legal foundation of this is firmly in our court. It's pretty obvious to anyone who reads the law and understands it at all. And even it's pretty obvious to Bromke that he doesn't have the foundation here. But hey, who knows?
But then at the pretrial or at the
oh, we have a raid from the Glarer. What's up, Will? Nice to see you guys over here. Happy to have you. Right now, we're going through the appellate hearing in my body cam footage. Mongoose Dog says Nickstown hates him. The footage is going to get released. You guys keep running with that. Like I hope it works out for you. You all say it very confidently.
Of his hearing stage. And then certainly later on.
That was after they were mistakenly marked as admitted.
No, before that they were mistakenly marked as admitted.
Well, the request for access was after the omnibus hearing.
Right, but you asked my position on when they were.
Yeah, and maybe I misunderstood your response, but I thought you said it was when the court reviewed them, and I thought the court reviewed them for determining providing public access.
They did, yes, on May 1st as well. There's another.
I was sentenced on April 18th. The May 1st request was later, right? And so he's saying May 1st as well. But that's the only time it happened. It didn't happen at the omnibus hearing, which would have been months and months and months prior. He knows it happened in May 1st. That's when the judge reviewed it. Of course, it was the same judge. So it would be interesting that the judge would need to review that footage that he's already seen and is part of the record. But again, this is where he's trying to do some sleight of hand before the appeals court. Considering the appeals court judges and their clerks will go back through this transcript or the recording and go through this stuff if they have any questions about it, this is not a great strategy. It's hard to hoodwink the appellate court judges because, again, they have a bunch of time to put together their opinions and they have a bunch of other people who are looking at it at the same time.
Order. There's two separate times at which the court reviewed the evidence that was submitted by Mr. White. One was during the criminal case when it was ongoing, and then there was afterwards for
wait, I'm sorry. When are you saying exactly the court reviewed it during the criminal case?
In advance of the omnibus hearing at which it determined that the issue that Mr. White had brought up was more properly brought as a motion in limine issue.
And what's your basis for saying that the court reviewed it? Because the court in its order said it didn't rely on those exhibits.
Because the statements that were made by the court specifically say that it was a motion in limine issue, not an omnibus issue.
I don't know that means the court reviewed the exhibits. I don't think the court actually said that in the transcript. So you're inferring something that isn't expressly there. Would you agree with that?
Not necessarily, no.
Can
Not necessarily. You're inferring something that's not expressly there. Do you agree? No, not necessarily. Well, then it has to be expressly there. Can you point to where it is? And
you point me to where in the transcript do you think the court said it reviewed the exhibits?
Well, it did that in advance of the May 1st order, which it specifically stated. It described what was the content of the video.
Well, where in the record can you point me to support your view that the court reviewed these exhibits prior to the omnibus hearing? You need to support your position with the record before us. That's what our review is limited to.
Apologies, reviewing the transcript here.
Because we're familiar with your briefs, we're familiar with the transcripts and the record, and I don't recall that, but maybe I'm just not recalling it at this moment.
she's not recalling it because it's not there. Because again, if it was there, he would have this prepared. This is a core pillar of his argument. And he doesn't have any authority, and he doesn't have citations to the transcript or anywhere else in the record. All he has is this inference that he made, and again is trying to breeze past the appellate court judges. But the appellate court judges are good at doing this. This is what they do. Issue spotting is the primary function of the appellate court. Issue spot and then apply the rule. The question is, what is the rule that needs to be applied? After that, it's just math. The appellate court isn't there to interpret or change the rule. It's, is this rule appropriate? Apply the rule.
Well, you can answer on rebuttal. Your time is up. Thank you, Chief Judge.
Ouch. You never want to go out like that, right? Like, he went out not answering the last couple questions, and it was a pretty long accumulated time of silence, well over a minute of silence from him, other than to say, no, not necessarily, in regards to whether he it was explicitly in the record or not. That's a crazy answer for him to give. If you are preparing an appellate argument like this, you have this answer. You know exactly what's coming. Cyborg Valkyrie says, be fair, this guy is about as well prepared to present a reasoned legal argument as Kurt is. Look, I don't know Oliver Bromke from a hole in the wall. I don't know anything about him. I don't have anything positive or negative to say. You know, he's a lawyer from North Dakota who's licensed to practice in Minnesota. Perfectly fine and reasonable. What I do know is that he's got a very tough legal argument here because he doesn't have any support. So I don't want to say he's not prepared. It's not that. It's that there isn't something to prepare. His position isn't supported. And so you have to kind of, now this happens a lot. And again, it doesn't mean that you ultimately lose on the issue, because what it means is you take a beating at this stage. You take a beating at the Court of Appeals. Now, maybe they then go to the Supreme Court of Minnesota. Minnesota Supreme Court accepts the case. And when they hear it, you know, at that point, he makes this very compelling public argument about, or, you know, public policy argument about why it should be allowed. And the Supreme Court reverses course and changes their existing ruling. That happens. I mean, it fucking happened in Roe versus Wade at the U.S. Supreme Court level, right? And they lost every step of the way until they get to the Supreme Court, and then it changes. So, like, you take a beating at the appeals court when the existing precedent isn't in your favor. That's how you change the precedent. So I'm not making anything, like, he seems to be well prepared as far as you can be. There just isn't anything to prepare. There's no Minnesota case law on this, and there's no analogous case law that's favorable from Minnesota or the Eighth Circuit. And then the closest analog he has nothing to do with this issue. So he's just doesn't have anything. That doesn't mean that you know, that you won't get your ruling. In this case, though, this isn't a massive public issue. This is a very niche public issue that involves, you know, a very dedicated group of people going after someone who isn't challenging the police narrative or anything like that, as far as, you know, the details of the crime that I was charged with and the crime that I was ultimately convicted of after a guilty plea. So you've got a huge issue in that there's not like a massive clamoring for this. There's not public outcry about this stuff not being available. And there's a very simple and logical reason why. Because when they're in outcry of this stuff to be available, is because the outcry is typically coming from the defendant or from the victim of police brutality or police use of force. It's usually the state is holding this footage going, fine, like, you're the subject of it. Here you go. And we want the body cam footage released. If I wanted the body cam footage released because I thought the police acted like in some sort of way, I could just I could release it. I have it, or I could sign, you know, the documents and have you know, I could get everybody's consent and I could have them release it. Like, that would be there. It's not like the government is holding this back because the government doesn't want people to see. They're holding it back because it's the law. That's a huge difference between a use of force incident or, you know, an allegation of excessive force or coercion or some, you know, improper prosecution. Those are different. There's different postures from all the parties involved. This doesn't happen because this isn't about that. That is pretextual and it's false. Again, the person perpetrating this has openly stated that that's not the actual reason that he's doing it. When that happens, you create this issue. And if you're going to go to the Supreme Court and be like, so and tell them this highbrow notion of nobility about the transparency of the courts, et cetera, et cetera, et cetera. The Supreme Court is going to ask the obvious question. Well, what does the subject of the videos think? What do the subjects of the videos think? And their legal representative is going to say, well, they don't want it released. And the Supreme Court's going to be like, so what's the public outcry about? And then, of course, if they're, if they remand it back to the district court for more evidence submissions, the problems with what's been represented to the court here, that will become very apparent very quickly. So.
Of course. Mr. Bromke, you will have 5 minutes for rebuttal if you choose to use it. Mr. White, I understand from our coordinator here that you're intending to split time. I didn't receive a notice that that's what the intention was. Is that correct, though?
That was correct, Your Honor. But Mr. Baker's late arrival may prejudice him against his ability to respond to the questions the court asked the appellant.
What would you like? I'll just say, what would you like to do?
I'll handle it all, Your Honor.
Okay.
Okay, so yes, the county attorney either didn't show up or maybe showed up late. I'm not 100% clear on whether or not he showed up at all. But my attorney, Francis White, was going to handle the whole argument. If the county attorney showed up late and missed a significant portion of the appellant's argument, he won't be able to respond to what the appellant said. So him talking wouldn't be very useful anyway.
All right, Mr. White, you'll have 15 minutes. Go ahead, sir.
Thank you, Your Honor. Your Honor, my name is Francis Herbert White III. I'm here on behalf of Nicholas Rekieta, who is the defendant in the underlying criminal case and one of the respondents in this matter. As a defense attorney, I find myself in the very...
Patty Leather says, is this Nick's criminal case? Did he record it or someone else? Patty, look on the screen, man. Minnesota Court of Appeals oral argument audio recording. It's on the Minnesota Judicial Branch website. The court recorded it and the court released it publicly. Rita Castillo, how are you doing? Hola.
Strange position of being on the same side of the V as the state. I never really thought that would happen, but here we are today. And like the court is, I don't understand, the court has expressed to Mr. Bromke, I do not understand by what authority Mr. Bromke has brought on behalf of Mr. Hardin this action in this court, especially when you consider the fact that shortly after initiating this appeal, sending this matter up for an appeal, he filed the public access lawsuit in the district court, which would be the more appropriate venue for answering these questions. I agree with the court that the rule that the Supreme Court issued under MDES is in fact binding upon this court and is in fact binding on all of the courts.
Can you help me understand when this request came in, every time the district court had to consider this request or the intervention request and the request for the documents, did you and your client have to appear at those hearings?
Patty Leather, I did not appeal my criminal case. Well, I mean, I did appeal I appealed the denial of the Franks motion at Omnibus. This is before my conviction was completed. We lost that appeal. That's, why I ended up pleading guilty, is because our main attack on what was there was a procedural attack on the warrant. The facts as they were that I had a bunch of drugs. that was the facts. That was accurate. And so I pled guilty once my rights were exercised and my procedural options were completed. This is a separate appeal specifically for the purposes of trying to obtain the body cam footage that is being done by Matthew Hardin at the request of Joshua Moon.
As far as I know, there were no hearings.
There are no hearings. Okay. And
Marby Dog 65, Marby Dog It says another woman judge. Are they all women now? No. 2 of the judges on this panel are women and 1 is a man.
And so did this procedure delay the resolution of your client's case?
Well, I'd like to remind the court that my client is still under the jurisdiction of the court because he has a stay of adjudication. So despite Mr. Bromke's assertion that that this case is quote unquote more or less over, it isn't more or less over. There still are criminal sanctions that are potential. And therefore the case is still, I wouldn't call it pending, but it's not over.
Well, before the stay of adjudication was entered,
this is kind of an interesting point raised by my lawyer. Technically, my criminal case is not over because my criminal case involves a stay of adjudication and probation. And that during the pendency of that probationary period, I am under the court's authority and I have to abide by the probation agreement. And if I were to violate that probation agreement, the court would exercise its jurisdiction and it would be under the same case as a probation violation. So my case is technically ongoing. And then the final resolution of my case will be at the end of probation if I successfully complete probation, the judge will enter in an order that will dismiss the charges against me. This is one of the really big perks of the plea agreement that was kind of critical to everything. A stay of adjudication means that I'm not adjudicated guilty. I'm not convicted of this crime. I pled guilty. The court heard the plea and rejects the plea and instead offers a stay of adjudication on the condition of probation. If I successfully complete probation, I will never be convicted of this felony and it will be dismissed as if it were dismissed on day one. It has the same legal effect, which means I will not lose my rights to firearms. I won't lose my right to vote like I can currently vote because I'm not convicted. If I were convicted and there was a stay of imposition, or if I was convicted and pardoned, that would be a different question. But this allows me to preserve my rights and to not actually have a felony conviction on my record ever. I'm not convicted now, for example, and I never will be, assuming I don't screw up the probation terms, which so far are going really well. I've completed all the things. It's just for the rest, for the duration of probation, which could be as much as 5 years. It could be kind of as little as 2.5 years. I just have to do the random drug testing and alcohol screening, which so far has been no problem. I don't assume it will be a problem in the future.
Was there any delay associated with the processing of your client's case associated with these requests? I'm just wondering how this worked. This is a very odd procedure to me.
Your Honor, I am not in a position to answer that question because any delay that would have come from there would have been on the state of Minnesota, not on me. Mr. Bromke's communications with the state of Minnesota, I was entirely unaware of them until I had been informed by Mr. Baker that they were in fact.
So this is another thing that they try to do. They filed this request administratively to get these documents, which means they did this in a separate proceeding. Then we were not informed. Nobody who is in that video was served at all. And there are several non-government people who are in that video that are not in my immediate family. And those people weren't served either. No one was provided notice of this. And I think, that may weigh against them in this case and the other case, because it goes towards the dishonesty of the action. If you're presumably trying to get, body cam footage that someone has a privacy interest in, you would notify them or reach out to them. And that never happened. So that's That's another reason why any access to this body cam footage existed at all. If they had notified us, and I think Josh knows this, we would have posed it from the start. The improper filing would have been noticed right away, or classification that was done by the county would have been noticed right away and corrected prior to anyone being able to see this.
Asking the court to do something. I did not know anything had transpired before that, because there is a different procedures, an administrative type procedure to which Mr. Rekieta was not joined as a party. So while Mr. Bromke is here objecting to the fact that he wasn't allowed to assert his constitutional rights to a right of access and afforded due process, the same could be argued of Mr. Rekieta in that administrative hearing. He got an order from the court granting the limited access that he had without Mr. Rekieta being put on notice that access was even being sought. So there are two different constitutional provisions here at work. One is a constitutional right of a defendant to due process and equal protection, as well as a First Amendment question. And if Mr.
Is it your position that requests like this are critical stages of the proceeding for which a criminal defendant must be present for the consideration of the release of records?
So this is an interesting question by the judge. And again, this stems from the main problem, which is this doesn't happen this way. Typically, this is very unorthodox. It's not, there's not a rule allowing it or whatever. She's asking, should I be required to be present at the hearings about this release of information, et cetera, et cetera, et cetera. But again, it's not actually part of the criminal proceeding, and there was no notice given. And then there are other issues involved, potentially Fifth Amendment issues, et cetera. And you start to see why it's, an issue. You start to see why it's an issue maybe to have these body cams being publicly available. They complicate defenses, because like, let's say someone makes a statement against their own interest on body cam footage. Happens all the time, right? Did you burn down that house? Only because that bitch was inside, right? Like there's something like that. Things like that happen with relative frequency. Or, you get body cam footage of drunk people acting stupid, or something gets seen on body cam footage that maybe the officer didn't notice at the first pass. And then that body cam footage's public release would allow the police to then use that body cam footage and any statements made. They may be able to get that into evidence in a different way. The problem with this is maybe it's not actually admissible in and of itself. And you don't get to argue that if there's this big public discussion about what's going on. This is where the complications come in with all this. And there's severe Fifth Amendment implications going on, and even Sixth Amendment implications going on as well. When you get into the right to cross-examine your accuser, if there's public access to body cam footage during the pendency of a criminal action, and someone talks about something publicly, like on Twitter, or makes a YouTube video about something that happens in the video, and the prosecutors see that and then utilize that in part of their argument, then the original claimant is actually the person who made the statement, the YouTuber or the blogger or whatever, Twitter user, and you don't have a chance to cross-examine that person. The state just incorporates it into their argument. That's a huge problem. There are constitutional implications to that. So even Florida's sunshine laws, they carry those potential issues while an action is pending.
I remember when I used to get 8 balls and hang out with my 2 lady friends. We'd snort and fuck all night. Oh, so good. Cheers, brother.
Cheers.
Not necessarily, Your Honor. It is my position that the defendant should be notified that there is a request. I fully agree that the district court has it within its authority, whether or not there should be a hearing or not, or whether it will just accept submissions on the record. I haven't seen any governing authority that requires a district court to have a in-person or a Zoom hearing when the record suffices. As a matter of fact, this court very frequently, if a party is unrepresented, will not schedule oral argument. Those people are not deprived of due process by just deciding the information, making the decision on the briefs alone, even though the parties didn't get a chance to present oral argument.
Mr. White,
Cyborg Valkyrie, I believe it was May 1st. I'm not 100% clear on that. Because again, I wasn't served in that action. No one was notified at all, even though there's a serious privacy right being implicated there. Now, I see New York Renal MD says that he doesn't see any standing issues. Standing is a federal issue. It's not a Minnesota issue. So you've got a problem there about standing. There is in the Government Data Practices Act a specific privacy interest that's created by the status that the videos are confidential and then private, subject only to the consent of the subjects of the video. So you have a privacy right generated by statute, if nothing else, but generally you do. Now, if someone contests, like in this case, that, these should be released because they're evidence or whatever, like if they make that contest, that contest and say that, then the person should have the ability to respond to that. They should have the ability to say, or not. The judicial might be wrong, they'd be right, whatever. But that would be, the process by which rights are properly balanced against each other to determine if they're there in the first place and which one wins if they are. So I'll disagree with you on that. That again, there's a reason that the appellate court judges here are going, why did you do it this way? Why is this the case? We've never seen this before. And that's because it was done in a very strange way. And usually in a case where you're looking for body cam footage to be released is being held by the state, the defendant or the subject of the body cam footage is on the side of the people who want it released. They're usually on the same side, and the state is opposing it because of public perception, a fear of violence or something else, or because they found something improper that they're trying to cover up, stuff like that. Usually that's the case. This is a unique case. And I'm not saying that this case, that this use case scenario doesn't exist. This is going to become more prevalent, only more prevalent as social media grows and grows and grows, and streamers and content creators and whatever you want to call them start to have more and more run-ins with the law. We've seen a lot of them this year, and people are going to want to know. And so we may be creating, that's why I said earlier, you don't know how this is going to turn out, even though the legal foundation that exists right now is pretty heavily in my favor. But you don't know, because courts haven't dealt with this issue before. But the appeals court isn't the place that they'll win that argument. Typically, it will have to go up to the Supreme Court. And the Supreme Court can choose to change their precedent and address, maybe the new public policy argument or new information or a new angle that they hadn't considered before. Those are all reasonable things to do. Is just, again, at this stage saying I don't have the authority for it, and et cetera, that's a problem for their side. Mr. Digress says, I'm just relaying my own stories of drug abuse in the past for me, but damn, it was good. Cheers, brothers. Look, I've said it before. This makes some people uncomfortable. There's a reason that people do drugs. It's because, the experiences and things that you have on them it's a lie, right? Like they're flooding your brain with chemicals, dopamine or serotonin, depending on the drug. And it's lying to you, or oxytocin in the case of Molly, which is why you love everybody. Your brain is being lied to by these substances But that doesn't really matter. Like the experience that what you experience is this euphoric sort of thing. The reason people do them is because they're fun. They're also highly destructive. I'm not advocating for it by saying that, but suggesting that like the experiences and things that you have while on them are like bad or whatever, unless you get like a bad acid trip or something, but that they're bad would be ludicrous. If they were bad, people wouldn't undertake the risk to do them. They do them because they're looking for a good experience. And so, yeah, there's a bunch of really like great memories and wild stories that I have, but just because I have them doesn't mean that that's something you can do. That's the past for me. Hopefully it's the past for you too, brother. But thank you for sharing.
Big ups for Rekieta. Josh Moon has a broke dick from so much porn consumption. Any idea what drugs he could take to fix it? Peace.
It depends if he needs instant solution or if he's looking for long-term care. There's plenty of medical options available for him.
Are you aware of any legal authority that would permit intervention in a criminal proceeding to seek access to case records in that proceeding?
No, Your Honor, I'm not aware of any that would prohibit, and I'm not aware of any that would allow it. The only records, the only thing that I would have to rely on is the order from the Supreme Court as regards to MDES. And as MDES works, it is a staging platform. And until such time as that evidence is offered and admitted, it's simply there waiting to become a record. It is not at this time a record.
And counsel for the state isn't here, part of the oral argument, unfortunately. But from the briefs, it appears that
Mr. Digress gifted 5 memberships. Thank you so much. If you get one of those memberships, make sure you send a thank you to Mr. Digress. And who was it? Someone said, let's see. Snappy 650 says, "You're fucking up so hard, Nick." Not sure how, but okay. Sounds good.
your client, as well as the state, is of the view that intervention wasn't appropriate. Can you respond to that question or comment on that point?
Yes, Your Honor. The rights of a party or an individual to intervene in a criminal case should be reflected in the rules of criminal procedure. Now, I do know that when you appeal a criminal matter to this court, you sometimes rely on the administrative rules of civil procedure, but that's because there are no other rules that guide that. I'd like this court to think of what the consequence would be to allow intervention in a criminal proceeding beyond what Judge Frisch has suggested might actually happen in the delay of criminal adjudications. It would open up an argument for individuals to potentially initiate private prosecutions. Now, there are a lot of people out there who would probably love to engage in a private prosecution, particularly of government officials with whom they disagree. But that would create a problem, not just with the courts, but with the due process of the individuals who are being charged privately. I think by allowing non-parties to enter into a criminal proceeding, you are opening up a Pandora's box. It will have a sort of Damocles over the judicial system.
Thank you. With regard to the legal issue in terms of access to the records that was decided by the district court, what standard of review do you think is applicable to the district court's decision to deny access?
That's an excellent question.
Okay, so it is an excellent question. It is. And look, I like my lawyer a lot, but I have some stylistic critiques. I'm not the biggest fan of how he starts the answer to this question, even though he gets to the correct answer, which the correct answer here is abuse of discretion. And he will get there. But first he's going to say something about he would normally do this. This is just a stylistic difference, a rhetorical style that I don't prefer. I prefer to be much more direct in my arguments. But, this is one of the reasons you hire someone else to represent you, even if you could theoretically represent yourself, because your stylistic preferences may cloud your judgment in the moment. When you're working on behalf of a client and you have kind of a 20/20 view of their issues removed from them, you can rely on your own style or modify it as you see fit. Whereas if they're your issues, like for me, I'm like, no, I want to hit this and this and this and this and this, because this, this stuff at this point in time, I've cycled through this for well over a year of, a year and a half now of time since the arrest. So like I've thought through this. I have my own prejudices as to how things should be presented and what things are important and not. And he has a different perspective. That's why you hire someone, even if you could like have the training to do it yourself or whatever. But it does sometimes get frustrating. Mr. Digress, thank you for joining, as well as gifting those 5 subs. I really appreciate it. And we have...
Your Honors, Mr. Rekieta is being harassed by an internet autist. So rule he is gay and deny the petition.
Wait, is the internet autist gay or am I gay? What ruling are you asking for? Be clear, counsel.
Your Honor, as a defense attorney who's normally on the other side of the V, I would argue that this should be granted de novo review. But I don't think that's proper.
See, my personal theory is don't propose something and then say you don't think that's proper, because the court might just disagree with you. But if you don't propose it, it's not in the record. You just say, hey, I think this should be abuse of discretion, and you don't even bring up de novo review. Then, the court could say, well, counsel suggested abuse of discretion. However, this court disagrees. This court suggests it should be de novo review. De novo review means that they look at everything in the record from scratch, fresh, as if nothing has happened, and make their own legal determination based on the facts that are in front of them, right? That's what de novo review is. That's very broad. That allows the appeals court to interpret things from the evidentiary record in their own way. Abuse of discretion defers to the trial court. Sorry, defers to the trial court's observations and interpretation of any evidentiary issues that have come before it, and defers in some ways to its rulings of law, except for the matter in question. And then what it does is it takes the matter in question and it says, okay, is there a rule clearly on point for this determination made by the judge? If there is, was the rule applied properly? If not, is this a question that is within the discretion of a judge to resolve? So again, this is like things like objections, right? You object to the introduction of evidence. Well, the admissibility of evidence is discretionary for the judge. They have some interpretation on relevance and stuff like that. To find abuse of discretion, you have to say, okay, this is within the discretion of the judge, and the judge abused that discretion, which means they go beyond a clear error and into an abusive use of their discretionary authority. Abuse of discretion is a pretty high bar to meet, and a lot of deference is given to the trial court judge. So that's why you want that as the standard versus de novo. So that's the difference between our arguments. But like I said, he got there eventually.
Because there is no legal authority that was applied to the case to allow intervention, I think an abuse of discretion standard would be there. The appellant has not been able to cite to any authority that would grant him the relief that he sought. Therefore, I don't believe that de novo review is appropriate because it's not really a question of law, because he can't make it a question of law.
I'm sorry, Judge Kirk, were you about to ask a question?
No.
Appellant also argues, or counsel for appellant argues, that the district court reviewed these videos and therefore they are now court records that should be accessible. Can you respond to that argument first?
Okay, real quick, there's some further discussion going on in the chat about the government's access to this thing. So they said, doesn't the Cyborg Valkyrie and the chairman Lamau, makes me laugh every time, have asked/suggested that the government, does the government have access to this stuff beyond the 90 days past the investigation? And the short answer is sort of. There is the possibility to request that the records of it be destroyed. That can happen after the 90 days. The question is the investigation technically over? Is the real question, because in theory, maybe based on probation violation or whatever, the judge could revoke my plea agreement, or in theory, I guess, I could attempt to withdraw my plea agreement so long as the case is still pending with the stay of adjudication. You can make an argument that the investigation is still ongoing for that purpose. That's a thin argument. I don't know that you would win that argument, but if that's the case, then technically this is all confidential and this is all a whole separate problem. The government, the Minnesota Data Practices Act has a policy for the destruction of body cam evidence. It is stored for a period of time, and then, which is the 90 days past the ending of the investigation. And then each department head or commissioner or Data Practices Act agent in each specific county or district has the ability to set up a routine destruction of existing evidence or existing body cam footage for the purposes of, technological economy, freeing up space and removing clutter. So they have a policy for it. It's different county to county. I don't know the specific policy that our county has. For example, it's a very small county, and this is one of the first Data Practices Act issues that our county has dealt with ever on body cam footage, because it doesn't come up in small counties. Much more common in Hennepin or Ramsey County, where Minneapolis and St. Paul are. I think it's pretty obvious why. Higher populations, higher crime rates, stuff like that. Here it's not as frequent. So I don't know what those policies are. We haven't had to make that argument or anything at this point. But there is a point in which the government should have a procedure to destroy that data. They don't keep it around forever. It's just a question by county and district of what that policy actually is.
One time I had a friend that had Hawaiian fighting cocks. We were smoking meth and felt like it was a good idea to bet $100 on his birds. All his birds were killed right away, and we each lost $100.
Why are you sitting there smoking meth and watching cocks fight? Weird. Meth is something I would never, ever try. Holy shit.
In terms of whether you think the record reflects that the court did review the videos, and if so, when, and then second, does that change our legal analysis in terms of the Supreme Court's order on relating to Mindy's?
Yes, Your Honor. To begin with, I don't believe that the district court reviewed the videos, at least in the criminal proceeding. I can't speak to the other proceeding because my client was not privy to it. However, in the criminal proceeding, it was not reviewed. And it is clear that it was not reviewed because there's nothing in the record that says that it was reviewed. And the district court judge clearly stated in his order that he did not base his decision on the videos. Mr. Bromke has suggested to this court that the district court judge's assertion that this was more appropriate for a motion in limine proceeding is misguided, and proves that he must have reviewed the videos is misguided, because any judicial officer in this state can glean that exact concept from the actual brief that I filed, where I put in there the specifics of what I was asking the court to do. I asked the court to review this, and if you look at the transcript, you can see in the transcript he did bring that up, and I said I wanted to make sure that this was timely, because I had found another case, I believe from this court, that had stated when somebody brought it up in a motion in limine, they had and they should not have brought it up. They should have brought it up sooner, even though the district court was wrong. That was not reversible error. That was harmless error. So I agree with the court. It's not in the record that he reviewed it. There's nowhere in the record that he reviewed it.
Well, in terms of the omnibus hearing, but I think the court's order.
So this is where the judge is trying to resolve this conflation that the other attorney tried to pass off here, right? Which is that the court didn't review this in the criminal case. They reviewed it in the administrative case that was filed on May 1st, I believe. And he said they reviewed it in both cases, which is not true. Mr. Digress says the second part of that super tip didn't play. Oh, you got to make sure and hit the plus after you type in the second part. I think that's a confusing thing. I'll probably have to do a tutorial or two on it at some point. Says, I've been sober for more than 8 years now from blow and meth. Wild ride, but much more grounded you out now. Cheers, bro. Hey, man, keep it going. Congrats on your sobriety. I know there are days that it's harder than others, but that's an amazing accomplishment, and I'm glad your life is much more on the positive side.
Two dudes on meth watching cocks fight is the gayest thing I've heard today.
We were smoking meth and pole.
Initially granting access suggests that the court did review it, because it talks about the contents of it in terms of there being children present when the search warrant was executed. So, and that is in Mr. Hardin's addendum, I believe, at pages 22 and 23.
Mm-hmm.
So does that change our analysis in terms of whether that, given the administrative error in marking it admitted and then the court's review for purposes of the records request, in terms of whether the Supreme Court's order on Mindy's applies?
Your Honor, I don't think that that order gives us heavy lift as the appellant is suggesting, because there was a previous filing in the criminal case that I filed where I objected to individuals who had filed a request to record the omnibus hearing. And in my brief, I said that there were children present. And I do believe I said there were children present in the body cam video, and that
he did. And I remember this very explicitly, because this is this is another part of the case that's really important, and it speaks to why the child endangerment charges were ultimately dropped, and that is in response to his statement that there were children present in the body cam footage, and that there are children involved in this case. The county attorney sent a letter to the court, and that letter says there are no victims in this case. This crime is not a victim crime. If that doesn't tell you all you need to know about the posture of the county in regards to child endangerment charges, if you don't have a victim of child endangerment, you don't have a crime. You would have to have a child who is endangered or a child who has the potential to be endangered to have that. And the county attorney specifically stated there are no victims in this case. It is not a victim crime at all. So that was, part of the issue there. That's why I remember specifically that he mentioned it.
Brief. This was prior to my brief on the omnibus itself, I believe. So the court could very well have gleaned the information that there were children present from that, unless the district court specifically stated that it reviewed that. And finally, Your Honor, I would like to say this is more appropriate for the Data Practices Act.
Mr. Digress says, I'm saying you can do it too, day by day, much heart. Thanks, brother. I just want you to know, like, I'm struggling with plenty of things. Wanting to do drugs is not one of them. That has been one of the easiest parts of my probation. Very rarely do I go, man, I wish I could settle down with a drink or whatever. And I can't for the time being, and that's fine. But like those are not issues that I struggle with, but thank you for the encouragement. Like I said, there's a whole bunch of other stuff. There's a lot of fallout from something like this. It's going to take me a while to, get past all that. But for that one, I'm very fortunate that is not an issue I've dealt with again. And maybe it has to do with the substances I used or whatever, because it wasn't something like meth or opiates, which can be highly addictive. But who knows? Diamond says, sorry, everyone. My connection is going in and out in Beverly Hills. Lots of rain tonight. Trying to get back to home, back to Newport Beach. Well, Diamond, I wish you a safe trip home. Please make sure that you guys make it there just fine.
I looked at one of these two proceedings is a collateral attack on the other. This is not a proper proceeding before this court. The district court can access this under the Data Practices Act. The plain language of the Data Practices Act says that it doesn't apply to judicial records. Judicial records are governed by the judiciary, and the Supreme Court of this state has spoken just to that. As far as
there isn't any legal bar to someone seeking a record that might be retained by the executive branch and the judicial branch at the same time that I'm aware of. Are you aware of any? I mean,
this is another mild criticism I have of my attorney, who I think did really well overall in this oral argument. But I think he spent a little too much time focusing on what he's calling a collateral attack. And the judge here rightly calls him out on it and says, is there any rule preventing you from requesting something from the judiciary and the executive at the same time? No, there isn't. So, as far as I am aware, in this case, it's, if they want to say it's either evidentiary records or it's governed by the Data Practices Act, that's fine. I think the law on both of them comes to the same conclusion, but it's different questions for different branches of government. And I don't see a problem with asking both of them, even if it is ultimately annoying. And like I said, I think he got, I don't want to say, like, I don't know that he got caught up on it. That's the question that they asked him. So he's responding to it. I just don't think the collateral attack is that, like, I don't think it's that impactful. And I think that, words on paper and words spoken could have been dedicated to something else. But if the court is asking about it, it needs to be addressed. So I think he did a good job addressing it. I just don't think that I don't think it's on the best ground there in all honesty. Mr. Digress says, oh, I'm drunk now. I just don't touch anything else. Well, you know, the one thing you can touch is yourself.
Are you aware of any law that would preclude submitting two requests, one to the executive branch and one to the judicial branch?
I'm not aware of that, but as I stated before, one of these two is a collateral attack on the other proceeding. I see my time has expired. Unless you have any more questions, thank you, Your Honor.
Is there anything else from the panel?
No.
All right. Thank you very much, Mr. White. Counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. A motion to intervene is appropriate to assert the public's right of access in criminal proceedings. I've got some federal case law in here.
Okay, so he reserved 5 minutes of his time. He only went 10 minutes prior. Now he has 5 minutes left over for his rebuttal. So he's going to try and clean up anything that he thinks he missed. Here's where he spent that time going through his case binder and trying to find a federal case on point, which would allow private intervention in a criminal matter. Again, he's not going to find anything in Minnesota. I believe he's going to find something in the Second Federal Circuit. He'll talk about it in just a second. It's US v. Farah, F-A-R-E-H.
The Herald Company, 734 F. 2nd 93 102. Vindication of the right of public access requires some meaningful opportunity for protest by persons other than the initial litigants.
Was that a criminal proceeding?
Uh,
I mean, my concern is that in the civil rules of procedure, there are specific rules that allow for intervention, permissive intervention and intervention as of right. But there aren't corollary rules in the rules of criminal procedure. And I don't think in the rules of federal or the federal rules of criminal procedure either. Oh, I could be mistaken. I just don't, I'm not as familiar, obviously, with the federal rules. Is there some authorized procedure here?
With respect to the rules of criminal procedure in Minnesota, I think we've established that there isn't a specific rule that allows for intervention of that type, but this isn't some improvised procedural maneuver. It's a routine nationally recognized method for vindicating a constitutional right that belongs to not to the parties, but to the public.
Is it?
Mr. Digress says, sorry, you're the only Dabbleverse offshoot live. Oh, offshoot me in the head for that. Thank you. So you get my BS and my money. Cheers, big dog. Hey, thanks, brother. I appreciate it very, very much. Thank you for that. If you check out Super Tips, bud, there is a karmic voice on there. I think we might have to get the gay No, we already have the gay karmic voice on there too. The karmic voice is on there if you wanted to use that. So he's arguing here, just getting back to the case, that this is not some improvised procedure, even though he literally is saying that it doesn't exist in Minnesota's rules. So it kind of is an improvised procedure. That's what he's going with. Again, he's on really shaky ground on all of this stuff. And he cited some cases. All of them were civil cases except for one. And that's where the judges are having a problem. They're like, the cases that you're citing don't actually stand for the proposition you're trying to achieve. That's not a problem, though. Lawyers do something called synthesis, where you take a couple different ideas from different things, you synthesize them together into a new thing, and then you make an argument by analogy that these things are like your thing, and the judges should treat your thing like this. So that's, this is just kind of part of the process that he's doing here. It's just not done well because he doesn't have a lot to draw on.
Though, I'm waiting to hear about criminal cases where this has been allowed.
I would request that the court grant some additional time to file some supplementary authority to that point. Just because the constitutional question here is an important one. It's the public access to criminal court records in a case where the defense and the prosecution have both taken the same position. US v. Arif 533 F. 3rd 7281 is expressly criminal. The other conditions, or the other citations that I have pulled up here are appellate petitions for mandamus forcing district judges to grant mandamus. but in United States v. Era 533 F 3rd 72.
Mandamus is a civil proceeding.
No,
Yeah. So again, he has one citation, US v. Aref. Again, that's AREF if you want to look it up. I thought about bringing it up, but this is going to get really, really heavy. And it's not, this stream's already going really long for the other stuff I want to do. But US v. Aref, if you want to look it up and read it because you're insane, you can. I'll just tell you flat out that the issues in US v. Aref are about prosecuting people in the context of being Islamic terrorists or something akin to that, part of a terrorist organization, involve national security interests and documents that are literally concealed from the public during the prosecution due to the alleged national security interests. That's not happening here. The government here isn't withholding the body cam footage because of some other thing. It's because that's the law. The law is they're not allowed to release it. And these guys are trying to go around that law, although they're not stating it. They should just challenge the constitutionality of the statute, of the Data Practices Act, and then of challenge the judicial records rules as violative of constitutional rights if they wanted to do that. But they weren't so brazen as to really go for that.
Yes.
In US v. Aref, the court reaffirmed third parties seeking access to judicial records can intervene directly in the criminal case to assert that right. I believe that's representatives of the press. The court accepted the procedural route as an obvious, uncontroversial way of doing it because access rights attached to documents and proceedings in that specific file. And the district court should follow the same rule. It's a natural way of.
And what case is that? Can you tell me that case again, please?
United States v. Era 533 F 3rd 7281, Second Circuit 2008.
All right, thank you very much.
Representatives of the press intervening to challenge closure and sealing orders inside a criminal matter itself is something that you would need to actually file into the criminal matter in order to do. So procedurally, it makes perfect sense.
And those were cases where there was a challenge to the closure of a courtroom?
I believe that case in particular, I'm not certain of the exact factual pattern underlying it, but
Closure of a courtroom is different than requesting a document. And
that's correct. I was referring to some of the other cases I was going to be citing, but the United States v. Aref is an expressly criminal case. And the issue at hand is access by the public to documents in a criminal case.
I lied. I'm going to show you guys the first pages of US v. Aref as soon as he's done, because I want to show you, he's stating this now, but when the district court goes into the citation, or the appellate court, they're going to laugh because it's a really bad citation for his assertion. We'll read it. We're just going to look at the very beginning of it in just a second because the order it blows his analogous assertion out of the water.
So I would submit that that the same principle is applicable here, especially given the public policy concerns of two parties that are nominally adverse, trying to coordinate to restrict the public access to those records. Procedural rules can't be interpreted in a way that diminishes constitutional rights. I mean, the cases I cited, Sargent and Ledoux, hold that procedural rules can't do that. Schumacher and Stark Tribune recognize a constitutional and common law right of access. The method specifically by which it's enacted, I think, matters less than the public's interest.
But you could still have a right to access through a writ of prohibition or a writ of mandamus, correct? So the question here is whether intervention is the appropriate avenue.
Whether it's the appropriate avenue, but whether it's impermissible, I would argue that it isn't. But in a criminal case, the most direct method of gaining access to specific records you want is simply to file into the criminal case itself. I recognize I'm out of time, so.
Anything else from the panel? All right, thank you very much, counsel, for your helpful arguments and submissions. The matter is submitted. We will issue an opinion within the statutory time period. Thank you.
So there you go. Statutory time period is 90 days. So they have until, as stated by Cyborg Valkyrie, it's They have until mid-February on that. Now let's take a very quick look at US v. Arif, which is Yasin Muhyiddin Arif and Mohammed Musharraf Hussein are the defendants, and the New York ACLU is the proposed intervener appellant. So there, in this case, Joshua Moon is trying to do what the New York Civil Liberties Union is trying to try to do in this case. Now, here's the summary of the case and what happened. Again, we're not going to get into the analysis and all that. We're just going to look at the summary and the issues that are there. This is laid out right up front. I went and checked. The defendants were convicted after a jury trial in the Northern District of New York. The district court denied a motion of the New York Civil Liberties Union, the NYCLU, to intervene in the case for the purpose of asserting a First Amendment right to discovery of certain documents sealed by court order. The defendants and the NYCLU now appeal. So in an accompanying summary order, we reject most of the numerous challenges to the district court's rulings. In this opinion, we hold that first, pursuant to Section 4 of the Classified Information Procedures Act, 18 U.S.C. Appendix 3 and 4, a criminal defendant is entitled to discovery of relevant classified evidence that is helpful to his defense. A decision within the district court's discretion that may be made without the defendant's or his lawyer's participation. So if you are, if you are being prosecuted and there are classified documents, you are entitled to discover those documents. Notice this is not necessarily about the public release of those things. This is where their first issue runs in. The body cam footage is not being withheld from the discovery process. It is not sealed and classified. It, I have them. They've been turned over to me as part of discovery. 2, so Section 2. We review denials of motions to intervene in criminal cases for abuse of discretion and find no such abuse here. So the level of review, abuse of discretion, again, that's what Francis ends up suggesting. My lawyer, Francis, ended up suggesting is abuse of discretion is the proper standard. And they agree here. Them finding no such abuse here is irrelevant to our case because it's fact specific at that point. And 3, district courts ordinarily should refrain from entirely, as opposed to selectively, sealing court orders and documents filed by the parties. But the district court did not err in doing so here. So you've got a case that says that, generally speaking, they shouldn't seal a whole file, but they did seal a whole file, and that was fine. This case is not good for Moon's case. Like this case has 2 major issues for them, and that's issue 1 and issue 2. Issue 1, there's no discovery disclosure problems here. Everything was properly disclosed during discovery. That happened in regards to the body cam footage. And then number 3, they shouldn't always seal everything, but in this case, it was okay. In my case, nothing is sealed by the court. The court doesn't seal it. There are rules about what is and isn't evidence. Those rules govern what happens with the body cam footage, or alternatively, it's governed by the Data Practices Act. On both of those issues, they lose. So unless they find and determine that the rule is improper or something like that, that would be the thing. But that's not what they're arguing. They're arguing that this, is when they're using this case, they're trying to draw an analogy between a court sealing it and rules existing that just say, yeah, this never entered the court at all. They've got a huge problem. So US v. Arif, not a great case for them. Mr. Digress says, off topic, have you reviewed the H3H3 copyright case yet? If so, what's your opinion? No, I have not. I have not. Hey, what's up, Foodie Judd 3269? Very happy to have you here. So yeah, that's that. Sorry that it took so long, but there's a lot to say on it. Again, This is a new area of law, at least insofar as Minnesota is concerned. And even in the places where this law is exercised, it's rare to have the same posture as we have here. So you notice in US v. Arif, as we were talking about, the defendants are on the side of the appellant, whereas in my case, I'm on the side of the respondent, not the appellant, because my posture is with the state's posture. And to be very clear, the state's posture on my case is neutral. It's just applying the law. Because if the state violates the Data Practices Act, they have a big problem. There's a cause of action for that from me towards the state. That is not a good thing for them to do. So they're just generally on that. There's never been any indication that they have a moral or judgmental position one way or another, that they want to keep the body cam footage quiet or they want to release it. I think they would likely be happy to release it, except the law restrains them. You can assume that laws restraining government, the government typically would want to do the thing. But I don't know. That isn't an issue in this case that has been brought up. So the government's not like aligned with me because they're like, oh yeah, we want it. Like that's not anywhere to be found. So the only inference is this is how they apply the law. And if the court told them otherwise, they'd be happy to do it. In fact, when the court did approve the limited release, like they just did it. They did it no problem like that. They're like, oh yeah, that's fine. They didn't levy an opposition to it. They didn't they didn't take a position at all. They just went with what the district court said. So now the district court says, you need to do it this way. That's their position. That's fine. Okay. So we're done with that, I think. Boomer Fox says 3 hours on a BS claim from a tard with tism. It's 3 hours for y'all. Imagine how long this has been for me. Oh my goodness. Okay. So let's do some fun stuff, I guess. So what should we do? Should we do this thing with Andrew Wilson? Should we do that first? Nolan Buxus says, hey, drug addict. I presume you're talking to me. Hi, how are you? Okay, hold on. I'm just getting this. So again, to preface this story, this is Andrew Wilson, who is an Orthodox Christian / dude who likes to tell women his particular view about the roles of men and women, which I support. I support people doing that. I don't want anyone to mistake and think that like, oh no, he can't have an opinion on this. He certainly can. And some of his opinions I very much agree with. Others of his opinions I don't agree with so much. But I want to say this because this I think is missed in all of this. The manosphere or meninist or men's rights movement, whatever you want to call it, doesn't really matter, has a particular approach that's pretty aggressive. I don't give a fuck. I don't give a fuck about that. Like, just because I might not take the same approach, it's not offensive to me. I don't care. Some people may take umbrage with what he says towards women. I think on this channel, he's probably pretty much in the clear. I think some women would agree with some of his positions and stuff like that. Here's what I want to say, though, about it. I want to do a mild apologetic for the harsh approach because, and I didn't always understand this, but I think I do now. Someone who's an Orthodox Christian who is begging and pleading with people not to ruin their lives in what they have determined will be catastrophic series of decisions. The harshness or the aggressiveness of the approach is designed, in my opinion, to sort of shock the senses of the listener and convey the urgency of the warning. They often focus on fringe cases of success and fringe cases of failure because both of those are possible outcomes, and you can't know. Some of these decisions take years and years and years to resolve on how they'll come about. So the desperation and the urgency of the pleading is that it has to be expressed how bad this can go. And it has to be expressed how good the right decisions can go because people need to make them. And the results of those decisions may not be immediately apparent in the moment. So I want to make a little apologetic in that respect for the harshness and directness of the approach. Even though sometimes I think, some guys say shit in the red pill community that I'm like, oh, okay, well, that was retarded. That's how I respond to it. But I hadn't really thought about it in the, if this is your core belief and you truly believe that the wrong decisions here will cause catastrophic, lifelong consequences, then the urgency and the harshness make perfect sense as opposed to not making sense. So that's my statement. So don't take listen to what he says and the ideas behind it more than the words that he necessarily uses. Because although we're going to focus on how he kind of fucks up in that approach specifically, for full context here, this recently happened on the Whatever podcast, and he's debating this woman and for 6 hours. And this minute and a half dominates. It dominates all of it. And it doesn't negate what he said, but it's got all the attention. And that's why it's really fucking important. So here we go.
I'll try to rephrase this. I'm going to reframe, and I'm just going to be totally honest with you. I will never be able to convince you of my worldview.
You won't.
I know. But the reason is not because I'm not a great orator or I don't make good points or I haven't said.
Okay, let's be clear. That line was really gay. I'm never going to convince you, but it's not because I'm not a great orator. I didn't make good points. I know that's not what he's saying, but that's how it comes across. No, I did really good here. I did great. Like if I can't convince you, it's not because of me. Like it's a you problem. And it is. Like ultimately, she's not there to be convinced. And internet debates, I hate when people are like, oh no, I'm like willing to listen to your side and hear you out. 99% of the time that's not true. They may want it to be true, but it's just not. Like you're not going to take the words of some retard yelling at you. And I mean that both ways, particularly for people who are engaged in a debate with me. You're not going to take the words of me, the retard yelling at you, and be like, you know what? I'm going to change my worldview based on it. It may plant the seeds, but the goal isn't the other person you're debating in an online debate. The goal is the audience. If it's an interpersonal debate and you're having a discussion where you sit down, it's just you two across from each other, candlelight's going, Barry Manilow's playing, you're rubbing legs, maybe gently brushing beards together or whatever. And you have that discussion, that is to convince another person. Doing it in front of, an audience of hundreds of thousands of people is fun. And, the sort of the format begets a little bit of name calling and some drama and theater thrown in. But your goal is not to change the mind of the other person. It's to change the mind of every other person than that person. Does that make sense?
Things which should be compelling to a person. But Charlie, I just think, honestly, you're too fucking stupid to understand them.
So,
and I have no problem with ad hominem. in debates like this, because again, the entertainment value is a big part of it. Everyone who's going into a debate like this knows that ad hominem is part of the deal. It kind of goes back and forth. So people also don't understand ad hominem from a logic and philosophy perspective. Just because you insult someone is not automatically ad hominem as a fallacy. Ad hominem as a fallacy is that the insult is the reason that their argument is invalid. And that's kind of what he does here. So that's the legit ad hominem. Good job. You're too fucking stupid to get it. You can't make a coaching argument back, et cetera, et cetera. That's an ad hominem. If you just say, you're fucking stupid. Why you're wrong here, though, is this and this and this, then the you're fucking stupid is actually like, it's irrelevant and superfluous. It may impact something, but it shouldn't really have anything to do with the breakdown of the argument. The logical discussion happens after that. If you're just walking down the street and say, hey, you're a fucking tard to somebody, like, that's not ad hominem. You're not trying to invalidate what they're saying based on it. That's just an insult. And people mix that up all the time, especially on Twitter. They're like, nice ad hominem, bro. It's like, no, I wasn't trying to invalidate you. I'm just calling you fucking dumb. Like, that's it in general. That it has nothing to do with the argument that's going on. Anyway, back to it.
Andrew, can I sell you on my worldview?
Yes.
Your wife has 3.
So he says yes to this, and that's what I'm talking about. I don't believe the online debaters who say yes to that question. He's saying that if she makes a logical argument, he's going to become a lesbian feminist. I mean, I guess he's a lesbian now, presumably, but he'll be a feminist. I don't buy that for a second, but people do that all the time. They're like, no, I'm like a hardcore Christian or a hardcore atheist will be like, oh no, I'm totally open to your worldview. And if you convince me logically that God exists, I'm suddenly going to be baptized tomorrow. Like, no, you're not. Like, stop. But who cares?
Can I sell you on my worldview?
Yes.
Your wife has 3 baby daddies and has been married twice before.
And you
you
lick sniz.
Under your
you lick sniz. Me too. Me too. I'm supporting my sister Sniz Licker. To all the Sniz Lickers in the chat, we need to stand up and save this queen. She has immediately gotten under his skin here, and this is where he fails. This is where he fails. She mentions that his wife has 3 baby daddies. He's one of those baby daddies. Her first baby daddy, from what I understand, I don't know. Rachel Wilson is her name. I do not know this person. I don't have anything against her or her past. I don't care. I just did a basic reading to get some of the facts here. And this is what I understand it to be. If I'm wrong, I'm sorry. I don't think so. Her first 2 children came from her first marriage, which she said she married her high school sweetheart, whom she started dating when she was 16. The first child was when she was 20 after they were married, and then they had another child. Then they got divorced. I don't know how long later. It was a little vague there. And then she was dating a man in a long-term relationship, and she had the 3rd child. And then, but they never married. And then Andrew Wilson married her, and she had 2 children with him. I believe she got married to him when she was 26 and maybe had the first child when she was 27. I'm not positive on those details. They were a little fuzzy. Okay. The problem that this lesbo is trying to point out is that he routinely states that women who are have existing children from a prior relationship or whatever and again, I don't want to misstate his position, because I think people in the red pill community's positions are misrepresented often. So I'm going to try and do my best here. If you're an Andrew Wilson fan, give me a little grace. I'm not trying to come after the guy. He is warning women that having these things lowers your overall desirability and reduces the chances that you'll have a successful relationship or a successful maybe life or be a successful parent in the long run. Statistics bear that out typically. That doesn't mean that any particular situation will work or will not. But this is a statistic-based moral argument. This is bad moral decisions will lead to poor outcomes. She's pointing out hypocrisy here because he is engaging in the allegedly bad moral outcomes. Now, pointing out hypocrisy is funny, but it's also an informal fallacy, similar to ad hominem. Just because someone has a hypocritical position doesn't make their underlying argument or assertion incorrect. You can say the right things and not do the right things, be a hypocrite yourself. It doesn't mean that the right things become not right just because you don't engage in them, right? Someone, this is a joke, but it's not a joke. Someone can say that drugs are bad and be doing drugs, be a hypocrite. And oftentimes people who either done drugs or in the midst are advocates against it, but addiction, kind of grabs hold of their life from time to time. So like, they may say drugs are bad and do drugs, and that hypocrisy doesn't invalidate the drugs, the position that drugs are bad. Just because someone breaks their own rule doesn't make the rule wrong. Okay, so that now it's not automatic. This is why it's an informal fallacy rather than a formal one, because sometimes the hypocrisy can go the other way. Like you can assert the wrong thing and act correctly as a hypocrite, and then but then your assertion is incorrect. So that's why it's an informal versus formal fallacy. But people misunderstand ad hominems and appeals to hypocrisy all the time. Just because they happen doesn't mean that they invalidate the argument. It takes a little bit more. But in this case, she's just bringing this up to get under his skin. This doesn't change his argument. And there's a better response to this, but he feels personally attacked. He feels like his wife's being attacked. And then here's where it goes. I'm gonna let it play out, and then we can talk a little more.
Religion.
You lick sniz.
What is that?
You're a fucking dyke. Don't talk shit about my wife, you stupid bitch. Shut your fucking mouth. Shut your stupid bitch mouth.
Your wife with the 3 baby
What did I
daddies?
just say?
Your
Dyke?
wife with the 3 baby
I'm sorry,
daddies?
dyke. Is she morally inconsequential?
I said I was going to let it play, but I can't. He got punked, lost his temper, and now he's trying to assert dominance over someone who doesn't recognize his authority or respect him really as a person, which is funny when people are like, you got to listen to me. You got to listen to me. And she's just sitting there like, okay. Yep. No, I don't have to listen to you at all. This is like a turtle on its back saying it's going to stand up and fuck you up one day.
In comparison to your ditch licking?
Do the men that you try to
Ditch licking is good. I'm happy because there's licking sniz and ditch licking. Neither of those terms, I always would say go to the taco bar or clean the taco shell. But now I don't have to use those border hopping phrases. I can use the good old ditch licking and sniz licking phrases I'm very happy about.
to
do the women that you try
show
to
your hatred against?
do the women that you try
convince them
to
that they shouldn't?
Charlie, did I
pursue
bring
women? Do they know
Charlie?
that
Did
your
I bring
wife
your
is 5
family?
years older?
Did I bring any of your
You called
family
me
into
fucking
anything?
stupid.
Did I
You
say
called
anything
me
about
fucking
your
stupid.
family being stupid, Charlie?
could.
It's
You could
because
go
I'm
for it.
better than you, Charlie.
No, it's because you're embarrassed, and you know that the traditional values that you try to sell people on are bullshit because
Let's
you
go
are not
through
a
it.
traditional man.
Chuck, let's go through it.
You are not a traditional
Let's
man.
go through it, Chuck. Tell me what I'm doing which is immoral.
Woo. Okay. to the lesbians out there, I love lesbians. I am one. It's great. I'm all for snitch licking and ditch cleaning and all this. She's right. He called her fucking stupid. He's like, you're too fucking stupid. And then she outsmarted him, which there's another clip of him from a year ago that I found while researching this, which is also really funny. Again, I don't care. I don't care about Andrew Wilson. I never heard of him before this clip at all. There's a clip from a year ago where he challenges the chick. He says that you need men to help you out. Therefore, you need to submit to men and you have no autonomy or something like that. And the help you out was that someone paid to have the woman try to open a pickle jar. They didn't have a pickle jar, but they have an olive jar because I guess Brian, the host of the whatever podcast, must be supremely gay. So they have an olive jar, not pickles. I would actually assume that they have an olive jar in the studio because maybe they pour some of these bitches martinis. I don't know. But yeah, so he's got an olive jar. We should maybe watch that. Scobie says, yo, the fact that you don't know the context of these clips is insane. I do know the context of these clips. I mentioned it earlier. This is a 6-hour-long debate. I said specifically that this doesn't invalidate his argument in the slightest, okay? But this clip is what's going to be remembered out of that 6 hours. And it does work against the moral message that he's trying to convey. Because he lost his cool in this debate, because he acted like this, people aren't going to pay attention to what he said. That's the point. But yeah, no, I know the context of the clip. I talked about it pretty extensively. I didn't watch the 6 hours of debate yet. I was through like 2 hours last night and I was like, holy fuck. I don't care about this debate at all. Like I don't know why we're still debating feminism. To me, feminism is, it's this leftover kind of third wave feminism seems to be losing its legs. And it's going to need a man to carry it across the finish line or whatever. But it seems to be losing its legs. And I think fourth wave feminism is going to go back towards the direction of first wave feminism. That's what I think will ultimately happen, is that the popular approach to feminism is going to be a softening and an acknowledgement of a weakening of power. The fucking Me Too movement is dead. It died with COVID when everybody realized they don't give a shit about that stuff. Now it's morphed into a general aggregate of DEI. Like it and Black Lives Matter went the fuck away. And now it's like, oh no, everybody's like really cool, so we should have diversity. And DEI is very dangerous, don't get me wrong. But like the individuality of the movement and the strength of that feminism wielded even if 5 to 8 years ago is gone. COVID annihilated it. Because everybody realized there's something more important, and that was not dying and, oh, the government shutting down our businesses and telling us we can't work. A8M31NWKA J4 says, Andrew Wilson did comment on your situation a while back. It is spread to so many corners of the internet now. It's like, where am I supposed to go to hide? Again, people are free to comment on my situation. I'm sure he had the whole thing nailed and knows everything about it, but like, who cares? It's not, he doesn't have to. But I'm not super interested in his opinions on it. Let's see. But with that, I think we got to find the pickle jar. Because it was just, this is like one of the most perfect clips that may have ever hit the internet. And I've got it, just a second. Okay, here we go. So here's the pickle jar. And now this one was, I think this is a year ago that this happened. This clip is from 5 months ago. Maybe it wasn't that, maybe the actual thing that happened wasn't that long ago. But holy shit. All right, let's do the hypocrisy fallacy. Bro, if you're going to advocate that men need to be strong and like masculine or whatever, this body shape is, I mean, those forearms are my forearms. Like I'm saying those are bitch arms, bro. Those are bitch arms. That's coming from me who has bitch arm experience. I'm with you. I feel your pain. So, oh shit. What's this? What's up, Mersh?
No Mersh voice on your super tips is egregious. I sentence you to 25 bings.
Yeah, you got to pay to send in 25 bings, motherfucker. I'm not going to sit here and bing for you. Bing, 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 bing. No, I'm not going to do it. What's up, Mersh? Yeah, why don't I have your voice? The fuck? I'm filing a formal complaint. Okay. So, so here we go. This is perfect.
Here we go. All right. Thank you for the light.
That was a little. That was
very
little,
harsh. I did not mean the table is very slick. Oh wait, I'm gonna refill my water.
Mary, can you do it for her? Oh, actually, no. She has one there. Never mind.
Oh wait, no. I can't.
Did you say he isn't even 35? Oh my God, I thought this guy was pushing close to 50. Holy shit. I don't know anything about it. Hold on. No. No. Closer to early 40s. He's 43 or something. I mean, I'm 43. He's gotta be somewhere around my age or older. At a time he was 35. At a time he wasn't even 30 yet. Okay. I don't care that. Okay, I think we've established that he is over 35. You caught me off guard with that. How fucking dare you? I'm like, there's no way. Like, he doesn't look bad or whatever. He's got some handsome features. I like his hair, and the graying in his beard is nice. Like, you know, whatever. I think he's a little soggy. Someone who advocates that men should be strong and powerful. Here we go.
I'll do it.
Force doctrine. There it is. See, right there.
There you go.
Thank you, sir.
She couldn't open the water bottle, so she handed it to Brian, and he opened it. That's funny.
Force doctrine applies to pickle jars as well.
My cat's name is Pickle.
We'll do a pickle jar pop if somebody sends in.
Are we opening pickle jar? Although
Yeah,
I am an exceptionally physically weak woman.
I don't know. You look pretty. Do you lift or?
You're funny.
I don't know.
All of 98 pounds.
We'll do a pickle jar challenge if somebody sends in a $1,000 TTS.
And the results are better for my kids.
Wait, 1 second.
1 second. Filibuster the debate.
Hold on.
Why is your mom calling in the middle of a debate?
I don't know.
Her mom doesn't know she's debating. How dare you?
Hold on.
Okay.
Hold on. Now we're going to let a couple chats come through.
So the dude sends in $1,000 for the crew. What's up, guys? Savage destruction tonight, Andrew. Cheers. If you ever want me to open a pickle jar, send me $1,000. Holy fuck. Whatever podcast makes so much money.
Champagne.
Yeah, that's for the
What up,
olive
guys?
jar. And then
Oh, I have to open it right now?
Yeah.
Okay.
Yes.
It's easier because it's an olive jar, though. Wait, put it.
My nail is fucking me up.
Yes, I do have a source for that. If you would like it, it's from the NIS. Anybody can find it. I just cited all of the statistics on it yesterday. Uh-oh. Come on, you can do it.
Put it right side up.
You can do it. You got this.
All right, bro. I can't do it. Here.
All right.
Oh boy. Oh boy.
Oh my God. I guess, yeah, Andrew, go ahead.
I'm supposed to open the pickle jar?
That is already one of the funniest questions, because him saying, I'm supposed to open the jar tells me something. He's not good at opening jars. And you know how you can tell? Because his forearms are shaped like mine. He's got bitch grip, and you can eat. Wait, I'm supposed to open the jar? You can do it.
It's like yeah.
Oh, jeez.
I do. This seems a little immature now. For
Hey, the guy
$1,000.
sent $1,000.
Yeah, but it seems slightly immature.
It's all fucking
it's just
slick
for-
now.
it's a little-
See, it
little fun.
is.
I got to grip it.
Uh-oh, Andrew. If you can't open it either,
Well, your hand greased the whole top of it.
my hand or mine.
Is that cope grease? Is it? What did she coat it in cope grease? Your hand greased the whole top of it. Wait, what are you talking about? Your hand greased it? Does she have greasy hands?
Fine. Here, high five. My
It
shoes
literally,
are as well.
it's like, feel it. Isn't that greasy?
It was like that already. Oh my God.
No,
you're
it
ridiculous.
wasn't. You greased the top.
Use
Oh
your
my
shirt.
Jesus,
Use your
Andrew.
shirt,
If you can't,
Grease the top with what? What is he saying here? This is such a weird thing. Women do love moisture. Yeah, maybe she's got lotiony hands. You know, someone could ask to smell her hands. Maybe her feet. Maybe she lotioned her feet with her hands. And you would go up and politely just be like, look, we need to know if you grease this jar. Can we smell your feet to see if there's lotion on them that you would have applied with your hands? That would make sense. I think that's something you can do.
open the olive jar. You cannot
Here,
blame my
while we're doing
hand.
olive jar.
If you're so strong, you should open it.
Yeah, I got to be able to grip it.
Okay, we'll grip it. Let's
It's
go.
literally slippery.
Uh-oh.
By the way, I just want to point something out. This jar is not slipping at all. It's not slipping in his grip. You can hear it as he tries to turn it with his shirt on. You hear the, like, you can hear him. He is not having trouble gripping this. It's really funny. This is great.
You cannot
Here,
blame my
while we're doing
hand.
olive jar.
If you're so strong, you should open it.
Yeah, I got to be able to grip it.
Okay, we'll grip it. Let's
It's
go.
literally slippery.
Uh-oh.
Grab me a paper towel so I can dry the top of it off.
Okay, once the top is dry, if you still
But do
can't
we
get it
now
out.
need to allow her another opportunity with the
Yeah, give her the paper towel so
Give her
that
the
No,
paper
I think
towel.
you should do it, Andrew. You're the big, strong man. There you go. Come on.
Here, I'm going to let some chats come through. We got some
Red
chats
Fox
while they're working on that.
donated
Red
$200.
Fox, thank you.
Deontology prioritizes intent, but threshold exceptions introduce consequentialist reasoning.
I'll let
Yeah,
you
but-
go first if you want.
No, Andrew, I greased it all up. There you
Are
go.
absolute. Introducing a threshold is ad.
Hold on. Look at this face that he... Right there. Oh, holy shit, that face. Oh.
Introducing a threshold is ad hoc.
Red Fox, thank you for that. Appreciate it.
I can't grip the fucker.
You can't grip it, dude. Your hand didn't slip at all. It didn't even move. Watch this motion. He's got every ounce of his arms. He doesn't budge. Again, if it's greased and slippery, you're gonna slide around. He didn't slide at all.
Appreciate it.
I can't grip the fucker.
Uh-oh.
Like, I got to have a way to grip it.
Jungle.
Andrew, I'm sorry. It's not.
My fingers slip
What a
right off the
backfire.
lid. My
His fingers haven't slipped. His fingers haven't slipped this little since the last time he was with his wife.
Fingers are literally slipping off the lid. I just can't grip it.
You know what? Maybe the olive jars are harder than the pickle jars.
They're not hard to open, but I can't grip the fucking thing.
Watch this shit.
So you can't blame me for my greasy fingers now. Like, God.
It's still greasy. The top of it's like,
You tried it with like 4
feel
minutes
it yourself. Tell me I'm wrong.
You know what?
Is that not greasy and
It is actually a
sticky?
little greasy.
Yeah, it's pretty fucking greasy.
I'm going to let...
But it's the top, not the
Lulu
sides.
donated $200.
Lulu, thank you for this.
Katara, you got good morals,
Who's
but you're not
Katara?
engaging with Andrew on the level in which he's challenging you.
Oh, he's calling me.
You're
you know what? Let me
Yeah,
comment.
this is not
about the
openable.
ideas you believe in.
Fucking Fort
Read a
Knox.
philosophy book.
Here, go.
Stand up. Put your back into it, lad. You can do it.
Okay, now I want it to be
I got
open. It's
this,
like pissing me
Pisses
off.
me off.
Yeah,
Should
I know.
should
it's
we have
fine,
Jake
it's
try?
You'll see the same thing. It's
Come
just
on, bro.
greasy.
It is,
See? It's
My
fucking
hand
greasy.
slided. My
It
hand
just slides
slided.
off of it. Yeah.
fine. Okay.
It's just too fucking greasy.
yeah. You
Wait.
know what?
You'll get the same thing. Come in here, Jake. You think, come on, you'll see.
That, yeah, you know what, is the closest thing, because he's saying it's greasy, isn't it? Isn't it? And Brian doesn't give it to him. And I don't think that was actually an affirmation of his point that it's greasy, because he's like, yeah, you know what? So then they called he called a man to help. He called a man to help. I would rather shove the jar of olives down my throat or up my rectum to just remove it from the conversation in shame at this point. But instead, the guy who suggests women don't have agency because they have to have a man help them just called a man in to get the jar for him. Holy fuck.
For yourself. You can't get your fucking hand on it. Try it. Nah, you fucker. That was bullshit.
He immediately opens it. No problem. Zero issues. It's fucking done. Look at her face. She is so smug. Right now in her mind, she's licking 38 snizzes. Oh, he was completely emasculated by the random dude and himself because will you come help? I can't. Holy fuck.
Shit.
All right. I just want to say for record.
We got a little olive juice. Let's get off the table. All right, guys. So
he used a tissue to do it, though. Andrew used the tissue too, and his shirt. He was trying everything. I'm surprised he didn't get out of fucking wrench. He'd be like, well, how do I do this? It didn't work. It didn't work until the man, and Brian tried to open it too, and Brian failed. Like he's wearing a flannel, but I think he stuffs it in the arms or whatever. But Brian's never claimed to be a big, strong man. Like Brian, I saw another video where he's like, I'm a fat ass, like I'm lazy, blah, 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 blah. He's not claiming, this strength or whatever. I think he makes a general claim. Men generally are stronger than women, which is obviously true, even if it's anecdotally false in any particular moment. It is obviously true that men generally are stronger than women. And Andrew Wilson, of course, that point that he makes is not wrong. This doesn't invalidate it. What this does invalidate, though, is his point that if you have to call a man for help, then you shouldn't have agency. And you are submissive at that point. It either invalidates his point or it makes him subject to the rule.
we have pickle jars for each of you.
Doesn't someone have to pay an additional $1,000 for me to open?
How do you know
another
they
pickle jar?
didn't?
Well, because it said it on. It says it on the screen.
That doesn't mean he shows every single
All
one
right,
of
just
them.
go ahead and give it. And we've given you, if you need to wipe it down or whatever.
I can't do this with my nails on, but okay. All right, I didn't get it.
Give it another. Come on.
No, it's
Gotta
so
tap it.
hard.
You got to tap it. All right, let's see. Do it on the table if you can.
Oh shit!
Wait, put it on the table. Put it on the table.
Oh.
Uh-oh.
Oh, I got myself.
Oh, no. There we go. Okay.
Just got to be.
He finally got the basic pickle jar open. Holy shit. Oh my God. Look, she found out that when you use your hands, sometimes you get liquid all over yourself. He found out that if you're going to clean what you clean, you better be able to open the fucking jar.
Wow, you undersold yourself a little bit. You undersold yourself.
That wasn't that hard.
All right, take them off the table, please.
Yeah,
well done
I
to
got
both
myself
of you.
very messy.
Well done to both of you.
I do just want to go back to some of the claims you made in your closing.
I fucking love that clip. His wife is currently getting a man to draft divorce papers. And that's, again, that has nothing to do with his overall arguments or points. I don't care. Like, I have overlap with red pill stuff, and I disagree with some red pill stuff. Whatever. Generally, I think there was a period of time where men were particularly disrespected in society very recently. I think the pendulum swung hard against men, and some really awful things happened to a lot of men. And there's still residual aspects of it. I do think the pendulum is swinging back, and I think that there's a correction that's taking place on that one. But as I said before, some people take these arguments a little farther or more aggressive than I would typically see them or take them. And that only means one thing. That only means that, in my opinion, that only means that they are so desperate to convey the message to rescue the people that they are talking to, whether they're right or wrong. They believe they have a moral impetus to rescue people from their bad decisions, and so that they deliver them in desperation for the purpose of salvation. That doesn't make them right or wrong, and technically, it doesn't even make them excusable when they act poorly or whatever. But it does make them understandable in a way that doesn't dehumanize someone just because of how they present a position. It also, how they present a position doesn't invalidate a single argument in the position. And that's something that we forget. But it may make it not so conducive to debate, but it's very conducive to entertainment. And Andrew Wilson's a very successful guy. Like, I'm not sitting here trying to claim anything about it at all. He clearly has the ear of a lot of people for good reason. He just, the ears are right there, and he just doesn't have the strength to push him away, I think. Ooh. Do I think Kurt could do it? No, I think his skin would fall off the moment he tried to turn the jar. He'd just flake off and it'd be a disaster. Let's see. Okay, so what is the other shit we have going on? Oh, yeah. So this is, let me pull this up real quick. We're not going to go too much longer. Boomer Fox says he uses some red pill talking points, but he himself is a trad con Christian morals debater. Yeah, great. Let's see. Where is it? All right. So this is very important. The science is in on this. But I'm sitting here. I got to go to the bathroom. So give me just a minute. I'm going to play a little little bathroom peeing song. I'll be right back, guys. But I'm about to pop. We'll be back in just a second.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when you're being is through. When you have small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, drink some when the stream is over. When you have small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Soaking your drawers.
Oh my goodness. Here we are. I'm back. How's it going, guys? I'm not going to do it now, but I do have another clip that was kind of funny. It was Pearl Davis, just Pearly Things. And she was debating she's kind of going after right-wing chicks or something. I don't know. I'm not really sure. I'm supposed to be on Pearl's show sometime soon. I'm just waiting on some proposed dates that will work. But I'm looking forward to that. That'll be a fun appearance, I think. Maybe. I don't know. It could be a disaster. Everything could always be really bad instead of fun, but I think it'll be okay. All right, this is very important. Toxic Brood 9002 says, do you plan on covering the Kirk assassination trial? I mean, sure, but that trial's got to be a long fucking way out. Okay, so this is the new this is the new hotness. Everybody that we don't like, this is not new at all. They all have a tiny dick. In fact, it's so small that it's called a micropenis. Everybody has one. And I feel like I'm really annoyed because I feel like they've stolen this from us. Just some lovely lady says, I'm sure she'll love glazing you while talking about how dumb women are. Look, I love being glazed. So comes with the territory of being a homosexual, I think. But here we go. They stole the micropenises from us and they gave them to Epstein and Hitler. What is a micropenis? All about the condition that may have plagued Hitler and Jeffrey Epstein. And I have to go back. I have to go back to this because, okay, didn't we get Hitler's body? Didn't we get that? Like, he got suicided or suicided himself. I don't know. in a bunker, as we were taking Berlin. I figured that he didn't cremate himself. And then, with Jeffrey Epstein, same thing. Shouldn't the autopsy include an official dick measurement so we can shame people in the afterlife or whatever? Mama Villa says we are truly in a clown world. I seriously thought your title was The Usual Joke. No, this is no joking matter. This is very, very serious. Men's health. Let's talk about micropenises. Last week, 80 years after his death, they burned the body. Yeah, but you think someone took a picture? If you walk in to the bunker, Hitler's dead. Tell me you don't take a dick pic of Hitler, right? And text it to all his girlfriends and be like, don't you miss this? Whatever, you have to. You have to take a Hitler dick pic. They never found the body. That's what they want you to believe. So here we go. 80 years after his death, Adolf Hitler made headlines for a surprising reason. DNA analysis determined that he may have had a micropenis. So, of course, they don't know this. They have no idea. There's a DNA analysis that says he may have had some condition may lead to a micropenis. I think this is just funny to me. The Nazi dictator was found to have a genetic disorder called Kalman syndrome. I think I met someone with this, which can delay or prevent puberty and result in underdeveloped sexual organs. And the revelations about dead men's anatomy keeps on coming, pun intended. In an interview this week, Jeffrey Epstein accuser Rena O claimed that the convicted pedophile had an extremely deformed penis, which was probably 2 inches fully erect. Now, I'm not in any way a Jeffrey Epstein defender. I think the guy should have died a much more horrible death than he did. But I also I'm not going to take the words of someone he sexually abused as automatically true. I'm just not going to do that personally. And again, I feel like this is one that there'd be some evidence to, back this up. O, who says she was groomed by Epstein, made the remarks in a recent Substack interview with Tina Brown. The 46-year-old said she didn't believe he was able to have penetrative sex, which is, that contradicts stories told by Ghislaine Maxwell, who I believe suggested that she had sex with him multiple times a day, that he had sex between 3 and 6 times a day, that the man was a genuine sex addict. But I don't know. I don't think she's reliable either. But this is just very interesting. Some people have described it as the shape of an egg. I'm going to read that sentence as Donald Trump, because I don't think some people have described it as the shape of an egg. I think it was more the shape of a lemon myself, and it was really small when it was fully erect. Very small, lemon-shaped nubs on each end, little plump in the middle, strange complexion on that penis. It was not good at all. Boomer Vox says, thanks for the responses in chat and verbally. It's a first for me, and it makes interacting in chat more enjoyable. I'll usually just listen while doing other things on my comp. If I happen to see interesting things in chat, I do try to respond, but I miss a lot. I know you guys are pretty funny sometimes, on occasion, when there's a pickle jar involved. She said, though she didn't call his appendage a micropenis specifically, her estimate of its size would land it in that category. Kind of little, very small, maybe a lime. How big is a micropenis? This is very important. an actual medical term, a micropenis, as opposed to not an actual medical term. What are they trying to do here? This is an actual medical term. Yeah. Yeah, we know. Micropenis is a penis that's significantly smaller than average. Oh. Based on correct measurement, a micropenis or microphallus is classified by certain lengths at different ages. Now, whoever conducted the newborn micropenis measurements needs to be killed, and the 5-year-old one, less than 0.74 inches for a newborn, less than 1.5 inches for a 5-year-old, and for adults, less than 2.9 inches. So that's it. To my 3-inch bros out there, don't worry. You don't have a micropenis. Your life is just fine. Nothing could go wrong and no one can say anything against you. While this condition doesn't affect how the penis works, it is an extremely rare condition affecting about 1.5 in 10,000 newborns in the U.S. Oh, and also 1 of 1 German dictators and 1 of 1 island-owning pedophiles. What causes a micropenis? While it can occur on its own, this micropenis just happened. It just happened on its own. Don't worry, nothing helped it along. This micropenis really took the lone hero's journey. A micropenis is often associated with several other health issues, from hormonal disorders or conditions that are present at birth. The main cause is fetal testosterone deficiency. Allegedly, you can't open olive jars. When a male fetus doesn't produce enough testosterone during development due to genetic disorders or issues with the testicles, hypothalamus, or pituitary gland. Fetal testosterone deficiency itself can be caused by a few different conditions. Prader-Willi syndrome. Come on. Sometimes it's too on the tip, right? Prader-Willi. It's like, Prater's like, I'm going to write about little dicks. I've got to find a guy whose last name is like something dick related. I have to do it. Willie. Oh, I know that guy, Willie. I mean, he's not a biology guy or an anatomy guy. He's in physics, but we can change that if we just plant the seeds. Prader-Willi syndrome is a rare genetic condition that affects metabolism. Hypogonadotrophic hypogonadism, when the hypothalamus and pituitary gland fail to produce enough hormones to stimulate the testes or ovaries. Okay, I think they're saying that women can also get this hypogonadotrophic hypogonadism. So it would mess with the ovaries, but yeah, okay, got it. Because for a minute, I'm like, I think if they got ovaries, they probably have a small dick, unless they're Michelle Obama. Kalman syndrome, rare genetic disorder that affects hormones. Sometimes a micropenis can happen with no known cause. What is Kalman syndrome? Hitler was recently revealed to have this genetic disorder in the documentary Hitler's DNA, Blueprint of a Dictator. This disorder affects the hormones connected to puberty and sexual development, as well as a sense of smell. I mean, I don't know how, we're just going to let it go. While the fetus is developing, certain genes change that disrupt the puberty process and cause the hypothalamus to not make enough gonadotropin releasing hormone. Without enough gonadotropin releasing hormone, which supports sexual maturity, sex drive, and fertility, puberty doesn't start, which impacts the development of sex organs. Besides a smaller penis, other symptoms of Kalman syndrome can include infertility, fatigue, low sex drive, balance issues, mood changes, and more. Boomer Fox, I believe it's because you tagged me on X. I know I saw it somewhere else also, but I think that was after you tagged me in it. How is a micropenis diagnosed? With a bunch of disappointment from a female assistant, I think. It can be diagnosed as early as birth or infancy, typically by the presence of both a smaller than average penis and foreskin size. You know, this was Hitler's Kalman syndrome was diagnosed by the rabbi performing the circumcision. I think it's got to be. It's got to be from the rabbi. He's like, oh my God, look at this little thing. Look at this little guy. I don't even know. A doctor will gently stretch the penis. And measure from tip to base, then compare the measurement to the size range of a particular age group. I don't know if I approve of this. Is there treatment? The two most common treatments include testosterone therapy and surgery, provided via injections or gel applied to the skin. Testosterone treatment has been shown to increase the size of the penis in studies of children with this condition. There's a lot of studying children's penises going on that I'm not quite comfortable with. I don't think so. Can you imagine the guy's like going to do the testosterone therapy? He's like, just put it on my hand. Trust me. I'll be back. I need the gel. I need the gel again. I need the gel again. Some water. Maybe some vitamin E. Let's see. Many adults may choose to undergo surgery for a micropenis to make the penis either longer or wider. There can be risks to this surgery, however, such as scarring, inflammation, having a bend in the penis. I'm sorry. What was that now? A bend, you say? A bend? Okay. A bend button, maybe? Having a bend in the penis, infection, or erectile dysfunction. While people of all ages can benefit from treatment, success is usually higher when started earlier. I love the tags. They have this filed under Adolf Hitler, Jeffrey Epstein, penises, puberty, and the date, November 19th. They have, well, where does this go? Oh my God. These $40 underpants are like a push-up bra for men's junk, a little boost for the boys. The 5 things men need for a normal erection, and a very common complaint for those who can't get it up. I'm a porn star who gets over 100 messages a day from men with penis anxiety. This is what I tell them. These articles sound fantastic and very, very useful for society. This little-known STI is often symptomless, but can lead to infertility, and it's grown more common than gonorrhea. 3 sex moves are most likely to break your penis. How to avoid an X-rated disaster. These are important. Sunken Cathedral says, Nick, do you use a penis pump? No, I actually don't get the whole like inflation fetish thing, or I don't, it's not inflation. What is it? But basically the idea of pumping things like, I've seen dark things. I've been on the internet for a long time, and I've never gotten or understood that fetish, like, from either perspective. So no thanks. Not at all. Read the next one. Man in shower. Man with world's largest willy slips, breaks arm in the shower because giant penis got in the way. What? Okay, hold on. This is too important. We need to know about this. We need to know about this. Here we go. Being well endowed isn't all it's cracked up to be. We know who wrote that sentence. Probably the person who came up with the micropenis article. We've heard of people whose mammoth members have injured their partners. There was the one guy. Do you guys remember? There was a Florida murder case where a woman asphyxiated, and the defense that the defendant raised, who was her boyfriend, is like, Look, I got a big one, and she just choked on it and died on me. And his lawyer's like, my client, Your Honor, is prepared to put his massive phallus on this weak table in front of the jury, just so they could see that she definitely choked to death. What a fucking, like, he was found not guilty for other reasons, but that was legitimately the defense that he brought. He's like, my client's dick is so big that it literally choked her. She was unable to breathe and she died. He's very sad by this. It was not intentional in any way, just a tragic accident. And he will unzip his pants and put his dick out so that you can see it. Holy fuck. Mammoth members have injured their partners. However, a UK man with the world's largest Johnson reportedly hurt himself after slipping and breaking his arm in the shower because his Titanic tallywhacker got in his way. This is a very English article, even though it's New York Post. It was a very embarrassing accident. Matt Barr, wait, not that one. It's not that one. Told Jam Press of the phallus-induced injury. This is the guy. Ladies, he may look like a male feminist, but he will wreck your femininity. Let's see. The AI specialist, sorry, I read ahead, frequently goes viral for his enormous unit, which at 14.5 inches long is reportedly the biggest medically proven penis in the world. Barr even has a cast of his Jumbo Johnson at the Phallological Museum in Iceland. Holy shit. Sir, is that your wedding dress train? Nope. Nope. Let's see. A preternaturally big penis might sound like a blessing, but there are myriad downsides. Look, you pray your cards are right. You have options. You have options. There are downsides, but it all depends on who you are. Including struggling to get dressed. Can you imagine? You're like rushing in the morning. You like wake up late. You're like, fuck, I got 5 minutes. And you have like a little bit of a morning erection. You're trying to put your pants on, but your dick keeps hitting your beard. You're like, God damn it, stop. Just stay down. Psh. Well, you have to have your morning pee and you like have to go in the other room and put your dick through the door. Holy shit. Feeling faint while erect. That seems like that could be fun, right? Like some people are into the whole like passing out thing. Well, like autoerotic asphyxiation produces the same type of effect. I think I've never tried that. That seems like I'm not David Carradine. I can't do that. And bizarre propositions, which he details in his book, A Long Story, Life with One of the World's Largest Penises. I think I need to read this. You got to read this. It can even be quite dangerous, as Barr recently discovered during a disastrous trip to the shower. One of the issues with being so large, especially in hot water showers, is that it's not exactly easy to see my feet. Okay, I'm sorry. Wait a minute. Wait a minute. I can't see my feet, plural? Your dick, I don't care how big your dick is. You are not blocking off both feet. Your dick gonna be 2.5 feet wide. No way. No way. The London resident recalled, as I was rushing to get ready for work, I didn't see the excess. Okay. I get what he's saying. He's not literally saying he can't see his feet because his phallus is in the way. He's saying he can't see the floor where his feet are supposed to go. That's what he's saying. All right. So he looks down. It's not that he can't see his feet. He doesn't need to see his feet to walk. He needs to see where he's going to put his feet. And if he's got like a giant dick, like sitting there, he might not. Okay. So. Ms. Dea's Vault. It's the Phallus Museum in Iceland, which, if I'm not mistaken, I've never been, but I think it's $50 a ticket to go. One of these days, I know someone who was recently in Iceland, and they told me they saw the Phallus Museum but didn't go in. I was very, very disappointed. Very disappointed. That is 14.5 inches. Is massive. And that's so it's unrealistic. Like you can't even picture it with any honesty. That is so huge. Oh my God. As I was rushing to get ready, I didn't see the excess shower gel in the tub because my penis was the only thing in my eye line. I slipped on it, causing me to fall out of the tub completely head first and crack my shoulder on the hard floor. Hard floor. Floor is always hard when he's around. Long story short, the well-endowed Brit sustained 2 fractures, what left him in excruciating pain and forced him to wear a sling. This picture is perfect. Well, there you go. There you go. If you're curious about the size, goes to his fucking knee. I'm sorry. I forgot I left this garden hose in my pants. Jesus. Criminy. Sorry, I didn't mean to say Jesus in this context. Jesus, the lawn care guy. What are these shoes? Look, I mean, if you're walking around with that guy up front, you can wear whatever the fuck shoes you want. It doesn't matter. It doesn't matter at all. Okay, wait a minute. I've done more analysis of this picture than is comfortable for me, but are we wrong? Are we wrong here? I was initially thinking, okay, this is his dick here. I don't think so. I think his dick is here, which is still unreasonably huge. But I had said, down to his knee because I was looking at this fold down here, but his dick, I think, is over here. It's both. It doesn't matter. It doesn't matter where his dick is because it is ubiquitous. It is everywhere. Anyone who sees that thing, it will be on their mind for the rest of their lives. They'll constantly be going, God, it's a big fucking... Whew. Okay, here we go. I've had close calls or minor falls before, but never anything this severe, said Barr while reflecting on the accident. Usually it's just been when I've had a partner in the shower with me. She's not in the shower with you. She has to be in the next shower over. He added, I've always been anxious about going into public showers because of the reactions I get, but now I'm a bit scared of private ones too. To help prevent future falls, Barr is resolved to shower less quickly and also to tuck his penis into his anus before every shower. He also bought a bath mat so he's less likely to lose his footing, even with his penis obstructing his view. It's one of the many minor things no one thinks about when it comes to having an abnormal body. Well, I mean, there's having an abnormal body and having a dick so large that you can't see the ground in front of you. That's not just like an abnormal body. Like, no one thinks about this. Well, no one else has a giant, like 14-inch dick in their way. Lamented Barr, who has since healed from his injury. While I'm naturally clumsy, it doesn't help that I have a different anatomy to most, especially such a large one. Oh, he's smiling. He's smiling the whole time. Prior to the accident, the Brit had... How long is this? This article is exceedingly long. Come on. This has to be fake, though. I won't go on a standard package holiday. Standard package holiday. Okay. Yeah, I got it. Okay. It's not really such a big deal, though. Like, come on. Some of the puns that they put into these things are like a reach too far. He's received some bizarre propositions. He recalled one bizarre instance where a guy asked to draw him in cartoon form as a giant and do all this giant sex stuff. A fetish known as macrophilia. That's weird. Due to his age, the Brit says he has no plans to cash in on his awe-inspiring anatomy via OnlyFans, as he might have were he half his age, explaining, I'm sure if I was 20 years younger, I would have, because I'd be far more focused on making sure my parents were all good. I'd be in the gym constantly, all these things. Bro, no one cares about your muscles. It's like, oh, I'd make sure I was in the gym. No one can even see it. Ben Cost is the author of the article. Someone asked if it was a man or a woman. It's New York Post, so it's hard to say, but Ben Cost, which I would assume is a man. That's pretty funny. I was not expecting that. Whoever said, no, Nick, look at the one, the next one in the shower. You gotta check that out. Let's see if there's anything else. I mean, to be honest, there was one in the article. It was like penis sizes by nation. That seemed like it'd be funny, but I don't think it actually would be. That's one of those where it seems funny until you actually look at it, and then you're like, oh, okay. 12 ways to improve ED, shocking sex allergy, made a 29-year-old woman infertile. Baby girl grows micropenis after laying on her dad's chest. This was an interesting story in general. We don't have to pull up the article, but so this guy was doing like chest time, where it's skin-to-skin contact with a new baby, and it's supposed to help with bonding and stuff like that. It's been around a long time. But he was also doing testosterone cream he would rub on his chest. And then, so he would do that, and he would then hold the baby in skin-to-skin contact. So the contact of that testosterone gel was going into the little girl, that's really fucking unfortunate that happened. Hot weather is killing your sperm. Plastic in your privates. Semen allergy is real and often misdiagnosed. Here are the troubling signs. Semen allergy doesn't seem like it would be that hard to diagnose. Honestly, like it seems like that one would become apparent when something happened. It's like, why is your throat closing up and you're dying? Oh yeah. Sid's disappointed on the bed. He does. This little picture here is really fucking funny. This is nuts, guy. I hate journalists. I hate it. Rita Wiggle. Come on, that's got to be fake. Her name is not Rita Wiggle. Small but suffering contingent of women. An allergy to semen is seriously interfering with intimacy. Semen allergy, known as seminal plasma hypersensitivity, is a rare reaction to proteins found in male spermatic fluid, according to the Cleveland Clinic. SPH is recognized as type 1 hypersensitivity characterized by rapid, exaggerated immune response to an allergen, putting semen in the same category as peanuts and pet dander. Those afflicted reactions to exposure to ejaculate run the gamut from burning, itching, redness, and swelling of the vulva or vagina to hives, shortness of breath, dizziness, and even anaphylaxis. Well, I think this, there are certain conditions under which that would happen. One Colorado college student with SPH suddenly became the least popular girl on campus. Reported that oral sex led to inflammation and temporary facial paralysis. That's really fucking sad. That's really fucking sad. She said that the severity of the side effects depends on the quantity of sperm she's encountered. Look, on Mondays, it's not so bad. But on Saturdays, after the football, it's way worse. Experts believe the condition, which can be life-threatening if there's anaphylaxis, is underreported. SPH was first documented in 1967 when a woman was hospitalized. 1967. Hashtag Israel, not a coincidence. When a woman was hospitalized following a violent allergic reaction to sex. In the next 3 decades, it was assumed that it affected fewer than 100 women worldwide. Yet a 1997 study led by allergist Jonathan Bernstein. I told you 1967 was not a coincidence. Jonathan Bernstein revealed that nearly 12% of reported postcoital symptoms could be classified as SPH. 2013, Michael Carroll, an associate professor in reproductive science, conducted a small unpublished survey that found a similar rate. However, he maintains that the true number may be much higher. Many cases go unreported, misdiagnosed, or dismissed. More common, 1 in 40,000 people. That's not 12%. Experts maintain that the main allergen is not sperm cells, but prostate-specific antigen in plasma. There appears to be cross-reactivity. Wait, what? What is someone in the chat? I'm not a doctor. Carol notes that CAN-F5, a protein found in dog dander, is structurally similar, meaning that women allergic to dogs may have a higher likelihood of experiencing the reaction. It's also possible to be exposed to an allergen through ejaculate. In 2022, OnlyFans star Lucy Banks shared her experience of suffering an allergic reaction to peanuts from her partner's ejaculate. You got to be so careful with peanut allergies. I mean, holy shit. This channel is so educational. Look, I didn't try. I didn't try for this. I didn't ask for this. She has since been spreading a warning to others about the dangers of sexually transmitted food allergies, especially from a peanut-loaded penis. That's Lucy Banks. Just to be clear, Lucy Banks is not allergic to your semen, but she is allergic to your semen if you consume sufficient amount of peanuts. While condoms mitigate the risk, for some unlucky lovers, allergies to semen and condoms make intimacy particularly troublesome. That would really suck, like, when you think about it. Like, I have a heat allergy, and, let's just say that when you're done, like, it can trigger the allergy in general. Like, you put in work. Depends on how hard you try, I suppose. And that kind of sucks sometimes. I get over it pretty quick, right? Like, I don't mind so much. But like this, this seems like it would be a more common issue if you had it. Like, that would be really fucking depressing. SPH does not directly cause infertility. Treatments would be antihistamine medication before intercourse. You got to take, so I don't know about the before intercourse thing, but like before a workout or a run, I tend to take antihistamines. And you have to take them like an hour before. So that would suck. See, they probably just are on a daily antihistamine. In cases where the allergic reaction is severe, some couples turn to IVF using washed sperm free from seminal plasma to avert the allergic trigger. Oh, that fucking sucks. God, that would be so fucking sad. Make sure you got your EpiPen because I'm going hard. I'm going to just do it anyway. Here it comes. In rare instances, men can be allergic to semen, known as post-orgasmic illness syndrome. The condition is characterized by extreme fatigue, weakness, a fever or sweating, mood changes or irritability, problems concentrating, a stuffy nose, and itching eyes following intercourse. These symptoms can occur within seconds, minutes, or even a few hours. After ejaculation, they can last from 2 to 7 days. Holy fuck. A week? A week? Can you imagine? Every time you ejaculate, you have those symptoms for a fucking week after? Holy shit. Uy 99 says I would also have mood changes or irritability if I came into contact with another man's semen. No, it's your own. It's your own. It's not coming into contact. It's nutting in and of itself. The essence of nutting. Can't take this shit serious. Shadefire says, wait, so because this usually doesn't work like that, but can you be allergic to your own semen? Yes. That's what they're saying. Well, there's 2 allergies. There's allergy to semen, which would, presumably you'd be allergic to anybody's semen, not just yours. And yours wouldn't be exempt. But the other one is this post-orgasmic illness syndrome, where it's not the same as like the allergy to the material. But it sounds like an autoimmune response to whatever's going on in your body. That's crazy. Believed to be an autoimmune response or allergic reaction, POIS is also diagnosed via skin testing. That's fucking crazy. That's insane. Autoimmune diseases are a brain bender in general. I agree. They don't. So like my heat allergy is, they believe, not mine specifically, but just in general, the condition they believe is an autoimmune response of some sort. But they don't really know what causes it. And there could be multiple causes to it as well. Maybe I'm just allergic to orgasming. Maybe that's it. But it happens when I don't, it happens when I just like run or whatever. Or lift weights. Or try. Or get angry. It happens all the time. So there we go. I don't know. I was not expecting to go through multiple penis articles today. I was just going to do the micropenis one because we have the Micropeen counter. That was all of it. Jamestown says you don't run. No, once I acquired the allergy, I stopped running for a long time. I've been running because I've been going to the gym, and that's my warm up. But it's not like before. When I was 34, I ran a marathon, so I did all the marathon training. I started off at 3 runs a week at 4 miles each. And then I basically every 2 weeks increased one of those runs by a mile. So it was 4:44, then 4:54, then 4:64, etc. And then once I got to a 10-mile long run, it was 6:10:6. I increased the shorter runs from 4 to 6 miles. So 6:10:6. And sometimes I would throw a fourth day of running in, but more than that, you really start to increase your risk of injury. So 6:10:6, 6:11:6. And then eventually it was 6:26. So I would do 6 miles. And then 2 days later, I would run 20 miles. And then the next day I would run, or no, 2 days later than that, I would run 6 miles again. And that's as far as I went on training. And then, of course, for the marathon day, you just push through the last 6 miles at that point. But that was when I was 34. I did that. I ran the marathon in October. I think it was Twin Cities Marathon. And then when I was 35, the next season I went out to start running, I was going to do a half marathon or something else. Maybe some 10Ks with the obstacles and shit. And after my first run, that's when my allergy hit, and that's when it started, and it's still there. So, but I have treatment for it now, but it's not perfect. But you need to, you gotta stay healthy. It doesn't matter if it's uncomfortable. Open a pickle jar next stream and let's see how many attempts it takes. Okay, I do pickle jars all the time. I don't know. I'll get one. We'll get one. I think I have one, but it's really late. I need to go to bed. Did you join the gym with Lady Rackets? Yes, we both joined the gym. It's a nice activity we can do together. We take a couple hours and go, kind of just hang out and work out and stuff like that. Run where the cops chasing me. I've never run from the police. Okay. Does Raggets have a slight case of monkeypox again? I don't feel sick at all. My voice sounds a little off. I felt a little bit of like soreness in my throat today. I don't know. Yesterday my voice was a little bit strained, but it didn't sound like this. It's worse today. All right, guys. Does she know I am watching? Wait, what? Lock 1245. Does who know I'm watching what? All right, guys. Thanks for hanging out with me today. Always a pleasure. And we should have... Do you have peanut allergy, penis allergy, or peanut penis allergy? I'm not allergic to peanuts. I love peanuts. So, we should have another stream tomorrow. I'm not sure on the scheduling of things yet. And then I'm going to try and stream more than once this weekend because of the 2 days that got fucked by Spectrum. But we got to get back to the trial of the porn chick beheading her boyfriend. I think there's going to be some wild stuff in that trial. So with that, thanks for hanging out with me tonight. We'll see you tomorrow. Let me get the outro video pulled up. See you tomorrow. You can follow on Locals and Twitter to make sure you're always getting, hopefully, notifications, because YouTube does not send them out very well still. This is what happens when you really don't stream for like a year. They don't send out notifications because they're like, oh, that channel's not active. It's going to take a while for that to kick back in. So if you really want to make sure you don't miss a show or an announcement, follow on Locals for free. You don't have to pay for it to just get those notifications. Or you can follow me on Twitter and try and get the notifications there. Both will work. Or you can, follow on Rumble and YouTube and maximize everything. So, all right, guys. Thanks for watching. As Wilding Soul says, tap a like on your way out. But don't use your hands. Use your massive 14.5-inch dicks to slap the like button on your touch screen. And then I hope you all have a wonderful night. And we'll see you tomorrow. Peace. Peace.
drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of the frog. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed